and to the use and storage of those images and sound recordings and any information contained in them for webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. I just have a couple of housekeeping issues first. If I could ask that mics are only turned on whilst parties are speaking, please. If anyone wishes to speak, could they raise their hands? It is quite difficult to see in these screens, so if you raise your hand and we don't immediately see you, if you could just bear with us, we'll do our best to try and get to everyone. And it's important that mobile phones are switched off or turned to silent for the duration of the meeting. DPA has no fire alarm scheduled for today, so if the alarm goes, you know it's time to leave. If anyone else has any kind of emergency, then please do leave without any hesitation. So the purpose of today's meeting is to discuss the arrangements for the inquiry and the associated procedures necessary to consider the case. There's no discussion of the merits of the case today. We are aware of correspondence to the DPA on a number of matters relating to the inquiry, just in the run-up to the agenda having been circulated. This meeting should hopefully address all the queries raised. If they don't, then there'll be an opportunity at the end. And I would just like to explain for the purposes of perhaps folk listening at home, there were limitations in what we could do and achieve with a Teams meeting. There's over 90 parties had responded to our letter of the 19th of June, confirming that they wish to take part in the inquiry. Those parties are considered, for the purposes of the inquiry, to have opted in to the inquiry procedures. However, given the high number, simply for practical reasons, it's been necessary to limit the number of parties actively participating in this meeting today. And those parties include the applicant, the Highland Council, principal consultees, organised groups and community councils. The many other parties who have opted in but are not actively participating in this meeting will still be able to do so and be involved in the inquiry, and we will go on to explain how they can do that. However, it's important that I make the point that, and we'll mention this a couple of times throughout the meeting today, is parties who've already opted in, responding to our letter of the 19th of June, will be required to reconfirm if they wish to go on to actively participate in the inquiry after hearing what is said today. The reconfirmation procedure will be explained as we go through the agenda. And parties actively participating in the meeting today will have been sent a copy of the agenda via a link. It's also available for other parties to view on the DPA website using the case reference, which is TRL-270-4. In advance of the meeting, the applicant, the Highland Council and Mr Kelly have raised their thoughts on matters covered by the agenda, and we will address those at various points as we proceed. Now, we aim to progress through the various points in the agenda, generally only pausing to debate areas of disagreement. However, given the number of parties participating and the number of items that we seek to discuss, we consider that it's probably appropriate to take a small break. We'll probably do that round about when we're discussing the timeline of the inquiry, but we'll review this after about an hour and see how parties feel. If at any time you want me to slow down, or if you're communicating with your team and you need a pause or a short break, could you please let us know? It's our intention that a note of this meeting will be issued by Tuesday, 18th of August, that's next week. Now, I don't plan to ground everyone who I can see on the screens to ask for their introductions, because that could take quite a bit of time. But parties who are invited to speak, who want to speak, could they introduce themselves before doing so? I'm now going to ask the applicant, the council, Nature Scot and Historic Environment Scotland to introduce themselves. I'll start with the applicant, please.
Yes, thank you and good morning. My name is Marcus Mackay. I'm an advocate and King's Counsel. I'm instructed by the applicant, SSEN Transmission, along with Lever Junior Nick Candrew, who's an advocate. And together we're instructed by Gemma McMillan, who's the Head of Dispute Resolution, Firm and Consents at SSEN.
Thank you. And the Highland Council, please.
Yes, good morning, ma'am. My name's James Finley, advocate in King's Counsel as well. I'm instructed by Rhoda Banfro, who's on the call.
Thank you. Nature Scot, please.
Morning, I'm Jacqueline Cook. I'm a partner at Harper McLeod. I'm here with my colleague Nana Crisp, acting for Nature Scott, statutory consultee. From Nature Scott today, Jennifer Heatley is also in attendance. She is the Energy Casework Manager for the North of Scotland for Nature Scott.
Thank you very much. And Historic Environment Scotland, please.
Good morning. My name is Ruth Crawford. I'm an advocate in King's Council. I'm instructed by Jennifer Jack of Harper McLeod on behalf of Historic Environment Scotland. Ms. Jack is attending as well virtually, and she's also accompanied by 5 individuals from Historic Environment Scotland: Victoria Clement, Oliver Lewis, Tom Gardner, Dr. Anne McSwen, and Catherine.
Thank you very much. Before moving on, I just want to make parties aware that Mr. Ian Kelly and Mr. John Heathcote are representing a number of community councils and some organised groups at this meeting. I won't run through them all, but we do have a list. If that list needs updated, then obviously you could amend that in the note of the meeting that we issue. On that point, it's important that we really kind of emphasise as we go through the agenda today that we'll be asking parties to consider if there is scope and merit in grouping together to make their case in particular topics or issues jointly, because we're aware that there's common issues amongst many of the people who've made representations. So we just ask that if you could be mindful of that once we begin to discuss the types of procedures that will follow for the inquiry. And if I could hand over now to Keith.
Thank you for that. Just quickly check that everyone can hear us speaking okay. Simple thumbs up might help, and just to make sure that everyone can hear us. So that was it, agenda item 1, and we can move on to agenda item 2 unless there are any preliminary early issues that are to be raised, but I can't see any hands being stuck up yet. So we'll go on to item 2, and that's a quick item for me to run through the guidelines that we will kind of operate to during this inquiry process. You may be aware through your involvement today that this application is one which is termed as a priority application for strategic transmission infrastructure. Unlike mainstream planning cases, there's no prescribed procedural rules for the conduct of an inquiry for such an application under the Electricity Act. But what the Scottish Government has prepared is guidance, and that's termed ASTI guidance, and you'll hear lots of parties talking about ASTIs. That is the acronym for Applications for Strategic Transmission Infrastructure. So that guidance was produced in February 2025, and it illustrated or illustrates how these sorts of applications would be processed, and it sets out key stages in the process. And it's guidance, not policy, but as an aid to those involved in the process. We will provide a link to all these guidance notes that we refer to in our note of the meeting. There's also the Code of Practice, which we intend to apply. That's the DPA Code of Practice for handling inquiries under the Electricity Act. That broadly mirrors planning appeal regulations, and the key aims of that Code of Practice is to ensure that procedures are fair, proportionate, and efficient, and allow a sufficient degree of flexibility, so that the reporters can exercise discretion in what procedures to adopt. So we'll link that in the note as well. I would also point out, and it's linked on the agenda, a reporter's guidance note which has been produced by the DPA on community hearings, and there's a specific item on the agenda about community hearings. So if you do have any queries on that, then those can probably wait until that item. So that's all I wanted to say on the guidance, and if you like, the framework within which we'll operate the inquiry. And links to those documents will be provided in the note of the meeting. And if that's clear enough for you, I'd be quite happy to move on to the third item of the agenda, which is about additional information. But is everyone quite clear about the guidance within which the inquiry will be conducted, and the fact that we will let you know what these are in the note of the meeting? I don't see any hands or hearing, so that's good. That's good. We can move on to item 3 then. That's termed as potential requirement for additional information. Now, for those not familiar with the term additional information, that relates to EIA regulations, and additional information normally have a capital A and a capital I. It relates to evidence that is directly relevant to the decision maker reaching a conclusion on significant effects of a proposal in terms of the EIA regulation. So it has a specific meaning. You can find out more about what additional information is by looking at the EIA regulations for electricity works, but we'll provide that link in the note of the meeting. Because those not familiar with planning appeals or wind farm inquiries or overhead line inquiries might not be used to the terminology that is used when you're talking about environmental impact assessment proposals. So we'll try and explain a little bit about that in the note of the meeting. So moving on to areas where we feel that there may be potential for additional information, I'll deal with the first couple of matters. One is with regard to a court judgment, which many on the call I think will be familiar with, but some may not be. It's the Ratio Farms judgment. So you'll be probably hearing or seeing that written down in correspondence quite a bit. That case concerned whether a wind farm development and its associated grid connection properly constituted a single project for the purposes of environmental impact assessment. So that's what that judgment was about. The key implication for this case, is that before making a decision on the case, Scottish ministers will require to undertake a specific evaluation of the proposal in order to identify what they consider the project is for the purposes of EIA, environmental impact assessment. We've had a body of correspondence already on that matter, and some of the correspondence in advance of this meeting has sought, if you like, a joint inquiry into the need for infrastructure proposed by the applicant across Scotland in light of this ratio judgment. So we're well aware of that correspondence that has been sent into the DPA. In relation to that judgment, this application, the initial views of the applicant were sought when the application was, if you like, transferred over to the DPA. When the applicants submitted their position statement, they were asked a few questions on the implications of that judgment. Highland Council were also asked, subsequently also asked to provide their comments on the implications of that judgment for this application and the matters that are identified in the EIA report. And a description of the development is set out, I think, in Volume 1, Chapter 3. So the council and the applicant have had an opportunity to set out their views on what ought to be included within the scope of this project for EIA purposes, and whether or not there is a requirement for additional information to be submitted. Those submissions are on our website, and we'll link to them in the note of the meeting. We have indicated, I think, in our appendices to the agenda that we would likely seek further written submissions on this matter. Those further written submissions are likely to provide an opportunity for those who wish to, or parties that will opt in, to give their comments on what the council and what the applicant have said about this. So parties who have got particular views about the implications of ratio for this proposal will be given formal opportunities to do so through written submissions. There may also be a further question or two for the applicant, and after that, the three reporters will consider whether or not additional information will be sought by us in order that we can complete our advice for ministers on this case. That was probably a bit too complex in terms of also maybe not used to kind of dealing with such applications, but the need for any additional information we think is required will only happen once we've had everyone's submissions on those matters. So hopefully that's clear enough. I know the applicant had raised in correspondence in advance of the PM what was being asked for. At this moment in time, we're not asking for any particular additional information. We are going to wait until we've had all the submissions in and then determine whether or not we have enough in order to report to ministers, for ministers to make that decision. If we need additional information, we will then ask for that. So has that clarified it for the applicant, firstly?
Yes, it has. Thank you, sir.
And, is that clear enough for the other parties, that you will have an opportunity to comment on what the applicant and the council have said already? You may wish to restate what you've said, but it's a formal opportunity. Everyone seems to be reasonably content with that. Mr. Kelly, do you have your hand up? Mr. Kelly.
Thank you. We would like to see written submissions and rebuttals on the issue of need. We have been asking for a quantified need case since the project first appeared, and it's never been provided. So we'd like submissions on that. You also have, as the additional item, update to cumulative baseline, which I imagine you'll come on to discuss. But looking at the submissions that have already been lodged by the Highland Council, they are looking for a very considerable amount of additional information. Normally, we go through a two-stage process for these early stage written submissions. And then more recently, the DPA has taken to asking that additional information be fully advertised and not just for the purposes of the inquiry. What I was immediately thinking is that whilst we're content with going through all of that two-stage process, if you do ask for additional information, then it's going to be very difficult to fix the timescale for the rest of the inquiry at this point, because there will be very considerable uncertainty as to what scope of additional information you will ask for, how long it will take to provide, and then it being advertised and responded to. So happy with the procedure, but I think it has clear implications for the inquiry timeline. Thank you.
Thanks for that, Mr. Kelly. And that is potentially true for other additional information requirements, that at any point during the inquiry, reporters could request additional information, and it may have an impact on any timeline that has been agreed. And for those that have been involved in the inquiries before, it's not unusual for timelines to be changed, although we don't anticipate that to be the case. So thanks for that contribution. You mentioned their cumulative baseline. I can move on to that. I don't think anyone else has indicated a willingness to speak on the ratio matter. This item, and again, the applicant was querying, oh, sorry, I see a hand up.
Yeah,
think
sorry,
Marshall.
Tina Marshall. Sorry, can you hear me?
Yes, we can.
Tina Marshall. I put together the energy strategy for Scotland in May 2025. It went to the petitions committee, and now the documents are in the various committees within the Scottish Government. From my own perspective, being in the north, you have problems at Spittal, and you also have this one as well. In my own view,
Marshall, sorry to cut across.
Economic on it and MSc in renewable economics. I think that the whole thing needs. Sorry, I haven't finished. The whole thing needs restructuring from Spittal upwards. Thank you.
Okay, sorry, I didn't realise it was going to be so short. I was going to flag up that this meeting is really just to discuss procedural matters and not to go into views on particular matters. That's what I was going to comment on.
Yeah, sorry. The thing is that I'm selling the company, so I won't be involved any further in this matter. Thank you.
Okay for that. The item with regard to cumulative baseline, it was simply to ask the question of the applicant, because it's quite usual to ask the applicant at this stage if there are any known updates to the cumulative baseline, whether that's landscape and visual impact or other matters within the EIA that they have planned. For example, in other overhead line schemes, recent ones, applicants have produced updated cumulative information. So it was simply a question for the applicant at this moment in time is about whether there was any planned submission of a cumulative baseline updates. So to the applicant.
Yes, thank you, sir. And often an inquiry procedure that is done in response to requests or suggestion by the reporter, and usually it relates to landscape and visual impact matters. If it would assist the inquiry and assist you, then we can certainly provide a comprehensive update to the other environmental topics. Either way, it can be provided by the date for the lodging of the foundation list, those documents. So yes, it can be provided in a more still version if that would be of assistance.
The question was really whether you had identified having a time gone on since the application was made and the submissions that you've seen. The question was just whether the applicant had identified a need to submit a cumulative baseline update.
The only issue that the applicant has identified that might be of assistance to on a cumulative basis would be in relation to the cultural heritage aspects. There's a limited potential for additional issues to arise. More generally, it's often the case that reporters find it helpful to have the landscape visual cumulative baseline updated. So those were the two areas where the applicant felt it might be helpful to the inquiry. But as I say, if it would be helpful on a more general basis, then that can also be provided.
So you don't propose, though, to or are you proposing on cultural heritage to submit additional information, which would be
if you're asking me to make that judgment, sir, yes, I think that would be of assistance, both on landscape and visual and cultural heritage.
It's useful we got to that, and we'll probably discuss timelines around that as we move on. I think Ms. McCallum can probably discussing timelines, and I think Mr. Kelly mentioned procedures around requesting additional information. Normally, cumulative updates are matters that we would require as additional information for the purposes of the inquiry. Therefore, they wouldn't be publicly advertised, which might not be the case for other additional information. So, if you were to be submitting that information, I think it would be our view that that would be for the purposes of the inquiry in terms of the EIA regs, if it's solely to do with cumulative baseline. Does anyone have any particular issue with that approach? Of
Can I ask a very quick question, please?
course.
It's a procedural issue. It's just related to the additional info that you were talking about. I have a very key letter from the CEO of the National Trust regarding cultural heritage. And when I inquired if I could submit it before this meeting, I was told that it was too late to submit it. Now, it is a very key letter and it has got some very, very key points in specifically regard to cultural heritage. When you're talking about additional information, is it only the advocates who are allowed to receive that additional information, or is it the participants on this meeting who can actually submit additional information, or would I have to submit that additional information to a third party, because it is a very key letter and it has got some really, really important points about cultural heritage, and I've been unable to share it as yet.
Well, the type of additional information that I've been talking about, sorry about the terminology, but that's got a specific meaning with regard to EIA regulations. So what we've been talking about very recently is additional information that would then form part of the EIA report. So that's why it relates to the applicant. And there's essentially two ways for that to appear. That is the applicant volunteering that they need to prepare additional information, because if they've recognises that, or the reporters formally requiring, on behalf of Scottish ministers, new additional information to be added to the EIA. Extra submissions beyond that is separate in terms of third parties, and we're going to be coming on to the procedures for each topic area. And on cultural heritage, there's an opportunity to take part, hopefully, in a hearing at some point. So that might be the opportunity to discuss that.
Great. Thanks a lot for letting me know that. Thank you. Yeah.
If you see additional information with a capital A and a capital I, and it relates to EIA regulations, then it's kind of formal information that then is part of the EIA.
I understand. Thanks a lot then. Thank you.
Okay, Mr. McCallum.
Okay, thank you. Sticking on the same agenda item topic, I just wanted to raise the issue of derogation. So this is probably something that it would need a bit more information to explain to all the parties, but just to keep it simple for the purposes of having an initial discussion on this with the principal parties. Since issuing the agenda, the applicant has advised that they propose to prepare and submit on a without prejudice basis what's termed a shadow derogation case in relation to the potential impacts on the Caithness and Sutherland Spittal Special Area of Conservation and the Nover and Moranges Forest Special Protection Area. Now, a derogation case, just trying to simplify things, is where the applicant will make their case where impacts perhaps cannot be fully mitigated and explain why they think the development should take place. So it's something that we would put forward to the ministers as part of our report, but it's a decision for the ministers at the end of the day to decide on that sort of matter. So what the applicant has proposed to do is make further submissions in relation to the response from Nature Scot on their consultation on the application, and in particular to the issue of Blanket Bog and the Flow Country World Heritage Site. So they have indicated that they will submit a package of information and expect that we as reporters will make a specific request that that information be submitted for the purposes of the inquiry. And as Mr. Bray explained, that would be information that wouldn't be subject to separate publicity. It would only be advertised as part of the inquiry documentation. So we intend to confirm our position on that and explain a little bit more within the PIM note, and we can discuss any implications for the inquiry timetable from that when we get to agenda item 6. But I just wanted to ask a couple of questions, and this is of the applicant. Can they confirm that the additional information that they intend to submit in relation to that matter will include not just Blanket Bog, but also the ornithology matters that were raised in Nature Scot's consultation response?
Yes, there will be information related to the SBA.
And I just wanted to give initially the applicant the opportunity to, if they wanted to see any more on that point at this moment.
I don't think there's anything really additional to say other than as when we come on to talk about the timetable, it might be possible to have written submissions on SBA related issues, whereas the hearing might be more for blanket related issues, but that's more a matter of timetabling the topics to be explored by different types of submission.
Yeah, I think we will be doing that. Thank you very much. Thank you. Okay. So first of all, I'm seeing, I can't identify who the person is. There's just an initial. Oh, Jackie from Timespan.
Hi there. Sorry, I've got the cold, so I'm putting the video on. Just wondered in terms of the additional information and the other information, the statements that will come in. I just wonder two things. First of all, will HES be responding with additional information to the applicant on areas of significant cultural heritage? And at what stage in this process, at this stage, to the meetings that will be coming up as part of the public hearing, will there be the opportunity, because it doesn't make it very clear about meetings in person and also meeting the applicant, and it would be really a good opportunity to meet HES and Highland Council at sites of significant threat. So there's a little bit in the agenda about site visits, so it doesn't make it very clear who or what that is for, and at what opportunity can we, as obviously putting in our objections, can be part of that process.
Yes, that is helpful. We do have various points on our agenda, both in terms of when we discuss the sort of options to participate and the procedures and the time frame, and all the steps we're going to go through to the inquiry. So hopefully once we get to go through all of those points, we'll have answered your questions. If not, then obviously at the end, if there's anything remaining, you can raise points then. But hopefully, I think we'll be able to cover everything that you've discussed.
Thank you.
Happy with that? Yeah. Okay, and I see one more hand. It's from John Heathcote. Heathcote, I think you might be on mute.
On the subject of cumulative baseline, clearly there are things that are already known about that are part of the baseline, but we're quite worried about what is to come in the future. There's many documents mention a future generation capability of 50 gigawatts, and this line is to transmit 6. So does the cumulative baseline take into account the transmission of another 44 gigawatts of power? We don't know where that's going to be.
Mr. Reid, do you want to answer that? I'm quite happy to.
In terms of future, cumulative baseline is if you're looking at landscape and visual, for example, there's almost kind of set approaches to doing that. Projects that are consented, operational, in the planning process and scoping and such like. What it can't do, and I don't think we'll be asking the applicant to do, is look into a crystal ball at the end of the day. So concern about what may lie ahead in the future is not something that we can easily foresee. So it tends to deal with the proposals that are known within the process, that are at early stages or through the planning process.
We normally agree as a cut-off point.
A date, yes. Yeah. But the applicant is going to submit additional information on cultural heritage and landscape and visual, as you've heard just not so long ago, and there will be an opportunity for people to comment on that, because that will be additional information. So you will get the opportunity to comment on that. So that might be an opportunity to raise any matters.
Thank you for that.
Can I just make a very quick response to Jackie from Timespan's comment? She said that there's an opportunity to visit cultural heritage. Some of the cultural heritage that I'm aware of that's going to be impacted is a good 5-6 hour walk uphill. And I can confirm that firsthand. I just wondered whether the people involved are going to be prepared to walk that length to see cultural heritage and how fit their legs are.
I have to say, the reporters are not always that fit for doing a walk of that distance either, but we can discuss site visit arrangements.
There's very practical issues there to consider, so just thought I'd let you know that.
That's fine. We will discuss the issues for site inspections when we come to that item on the agenda. Okay. Yeah. Okay. So I don't see any more hands. So I just wanted under the same. Thank you. Under the same agenda item, although it's not listed, I wanted to list the topic of agriculture at this point. So the applicant will be aware that there's been exchanges on this topic in both the Contour to Teeling and Beauly to Peterhead ASTI cases. And it's our conclusion that it's necessary for this matter to be fully assessed as part of the environmental impact assessment of the proposed development. And we seek to ask for the submission of additional information with the capital E, capital I, in this case under Regulation 20 of the EIA regs, and ask the appellant to publicise that information. So we intend to set that out within the note of the meeting and confirm that in the note of the meeting. But wanted to give the
objections to this project on the basis of agricultural impacts. So if there are issues that are thought to be of concern in relation to another project, which the reporters think there may be some potential for crossover, I think it'd be really helpful if the procedure notice to specify those specific issues so that it's absolutely clear as to what information is being requested.
Well, can I just check if we have Lorna Scott from the NFU Scotland present? Sorry, because my understanding is that we have an objection from the National Farmers Union on this.
Yeah, I'm here. Yeah, I'm actually covering it for my colleague who would have been involved in this, but I will double check and I'll come back. Yes, but I think we had objected and it would be on similar lines to the Contour Teeling, but I'll follow that up with the specifics.
Yeah, we do have a note in our, we've got a list of all the representations received, and we have got a record of a representation raising the issue of effects on agricultural land use, and obviously similar issues that have been raised in the two other ASTI cases. So bearing those in mind and bearing that it's a similar project with similar issues affecting agricultural land, it's our initial view that we would seek further additional information on that topic along the same lines as been asked for in the other two cases.
I understand. And the applicant will comply with any request that's made. You'll understand that also that the issue of land use and agricultural land use was scoped out of the EIA. And as I say, there's not any understanding that there's specific objections from affected landowners, leaving aside the expedition. But anyway, if you find of assistance, we're more than happy to provide it.
Yeah. There's been, I can't list individual names, but there has been farmers, individual farmers who have made representations in this case. And taking account of the objection from the National Farmers Union, we've considered this along with the two other cases, and that's our initial view. We will confirm it in the note of the meeting, but that's just to flag up that that's likely to come from us. Mr. Kelly.
Thank you, ma'am. I'm pleased you've set that out. My clients have a number of general concerns about what was scoped out of the EIA, and we most recently articulated them in the appeal statement for Fenelon, which of course is part of the same project. We may visit them again, but population and human health and major accidents and disasters are areas of concern. My clients were also concerned about decommissioning and waste disposal, but I'm satisfied that they can be covered by conditions, normal type of conditions on these matters. In due course, we'll make submissions on this, possibly in response to the minute of the meeting. But I do accept we're scoped out, and we are checking how that process came about. I just thought I would mention it, but we are very pleased to see that you've raised the agricultural point. Thank you, ma'am.
Okay, thanks very much.
There's a procedural point there, just in case anyone picked up on that, that I think we'll probably say it at the end of the meeting, but useful to say it now. There's not an opportunity to comment on the note of the meeting. The note of the meeting will be considered as a procedure notice, so we'll set out what procedures are. You will be able to respond to the requests that are made, but no comments are sought on the actual note of the meeting. I'm sure that wasn't what you meant, Mr. Kelly, but it was just to clarify for others that the note of the meeting is not a consultation. It would be a procedure notice that parties would follow.
I think I say what I had in mind was obviously you're going to be issuing the minute of the PIM in advance, well in advance of the Highland Council, considering the application at the joint MPAC and SPAC meetings on 9th and 10th September. I can easily envisage matters arising from the councillor's consideration of the application that might slightly be in conflict with the minute of the meeting, and I just had in mind that there might need to be a process of clarification. And you had already said at an earlier stage, and I was very happy with that, that it's not unknown for timelines and procedures to be changed as the case evolves. So that's all, sir. I wasn't wanting to make a formal submission on the PIM, just recognising that there's potential for change at a later stage, and you've already accepted that, so I'm very happy with that.
Thank you very much, Mr. Kelly. I'll move on to agenda item 4. You'll see listed a number of points. But before we run through and explain the inquiry procedures, I would just ask all of the parties who have already opted in to participate to note that they will be required to reconfirm their intentions following this meeting, so that we know that who will be involved at each of the different parts of the inquiry that I'm about to explain. So Agenda 1 of the Appendix 1 of the agenda sets out our initial views of the main topics to be addressed and the choice of procedures to be used, and those topics which are not identified for any further procedure. The appendix also indicates whether a particular procedure could be in person or virtual, and we'll come on to discuss that later. But before seeking parties' views in any of that, I just wanted to make a few important points. We emphasised that all parties who want to participate need to reconfirm in due course, and they should understand that they need to be prepared to submit their case in advance and to allow the other parties to see what evidence is going to be presented, so that there's no surprises through the process. The inquiry process, as Mr. Bray has said, is intended to be open, transparent and fair. So, having said that, not all parties are required to actively participate in an inquiry. Once you've heard what we're saying today, you might decide that you want to rest on your existing representation to the Energy Consents Unit. You're not under any obligation to follow up, even if you've already responded on the 19th of June to say you want to opt in. This is your chance to consider your position once these procedures have been explained to you. So again, I would say we would encourage joint working with parties and individuals who share common concerns or interests, so that there's a limited number of individuals taking the lead in presenting their case. Some parties have already done that. This approach makes the best use of resources for all, because we're very conscious that it's not just ourselves who've got to read a lot of material, everyone involved does. So one of the key points we'd ask parties to note is that they must be aware they've got to confirm their participation in any of the procedures that we set out in the PIM and any of the steps by Tuesday, the 1st of September. That's an important date to put in your diaries, please. I will address that again later. So just for the benefit of parties who are unfamiliar with the inquiry process, I just want to explain the various procedural options and the requirements upon those who choose to actively participate in. So as I said, any party can choose to just rely on the written submissions already made, and that would be either their representation or objection to the Energy Consents Unit or a consultation response to the Energy Consents Unit. Secondly, we have identified certain procedures where we think, or certain topics where we think we might seek further written submissions. And that process involves the reporters posing a number of questions to specific parties, requirements for information from specific parties. And in doing so, we then allow other parties that we may identify to comment in those responses or invite comments from the wider group of parties who reconfirm that they wish to participate in the inquiry procedures. Parties should only comment on the topics within their original representation. If you've only objected the grounds, for example, of cultural heritage, you shouldn't then include within your later submissions further objections on other topics. That adheres to the inquiries, rules and processes and code of practice that we've already set out. And it's important that all parties participating in further written submissions procedures strictly adhere to the guidelines that we will set out and the deadlines set out in the note of the meeting. So informal inquiry sessions are where we seek evidence, technical evidence in more complex matters. And in those cases, what you have is a participating party presenting their evidence from one or more witnesses. And usually the parties are legally represented with lawyers, and the lawyers will do the cross-examination or questioning of the witnesses, although it's not essential for any party to have a lawyer, and that can be accommodated. So even if you don't have legal representation, parties should be prepared to take questions on their evidence from lawyers or representatives from other groups. And we as reporters may have some questions as part of that process. Material is required in advance for anyone participating in an inquiry session, and that should state your case, normally an inquiry statement, an inquiry report, and for each individual witness of recognition. And recognitions are the detailed written statements that normally a party would either, or a witness would either read out or say this is their evidence to the inquiry. Quite often those are taken as read. They're normally limited to about 2,000 words in length so that they're concise and they can cross-reference to other documents, but they should not include appendices or other technical information or photographs. Anything along those lines should be lodged separately as documents by the date that we'll talk about later. Also helpful if recognitions are set out with page and paragraph numbers, and that those are submitted strictly in adherence to the deadlines that we set out. Now, for topic-based sessions, hearing sessions that we've set out in our Appendix 1, these would take the form of a structured reporter-led discussion, and all parties who reconfirm following this meeting that they want to take part in the inquiry can participate in a particular hearing session. We'll go on to talk about community hearings separately in due course, but talking about a topic-based hearing session, these don't involve any formal reading of evidence or cross-examination, and we prepare an agenda for each of the hearing sessions in advance, setting out questions that we will seek to ask or matters that we wish the parties to address. There's no need for legal representation, although parties' lawyers can take part in the discussion, and questions can be put to other parties via the reporters. Topic-based hearings are less formal than the inquiry sessions, but they still deal with detailed evidence. And in advance of a hearing, all of the participants would be expected to prepare a hearing statement with regard to the scope of the hearing. Now, we can set out bespoke procedures if we consider it appropriate for parties or individuals who have no representation, but we can deal with that as we go through the process and when people respond to us to confirm their participation. So just some basic information about community hearings, although we've got a separate agenda topic on that, but community hearings are just a further option that we consider are appropriate in this case. And these give an opportunity for individuals and groups to participate in the inquiry process by making a short presentation to us. And these presentations should again be based on their previous representations to the Energy Consent Unit. So for most parties, particularly individual members of the public, hearing sessions, community hearing sessions are likely to be the most appropriate forum in which to express their views on the proposal and to participate in the inquiry process, because these are non-topic specific, they're less technical in nature, they're better suited to parties who are not legally represented. They're less formal, and hopefully less intimidating for members of the public, because we know it's difficult for some parties to speak, but we hope to make those as comfortable as possible for the community taking part. While we may have occasional questions, generally what we're doing is just listening and hearing what the community have to say, what individuals have to say on the proposal. So we would strongly encourage parties with similar interests, again, to group together to make best use of time and resources for all, because there's only a limited number of dates for community hearings. But we would just remind parties that if you wish to participate in a community hearing, you must have already opted into the inquiry process. And by that I mean having responded to the letter of the 19th of June saying you wish to take part. Anyone who's not already confirmed that they wish to take part, we'll deal with that later on. Okay, and we will explain the process. So we would envisage that all of the sessions that we will hold for this inquiry, whether it be a formal inquiry session, a topic hearing, or a community hearing, will be recorded and live webcast. But this is subject to staff availability. But we would ask that any venues that parties are considering would need to be suitable for webcasting. We'll discuss site visits in a bit more detail later on, but this is another part of our procedures, part of our evidence gathering. So Mr. Bray and myself have already undertaken fairly lengthy site inspections on an unaccompanied basis, and we propose to carry out more, and we'll come to that later in the agenda. But what we would stress is that the type of procedure being followed, or indeed the absence of any further procedure, is not an indication of the importance of that topic. And where we've indicated no further procedure, it doesn't indicate that we don't think those matters are of importance. It's simply an indication that we believe that we've got sufficient information on that topic for the purposes of us writing a report to the ministers. It's also an important point for us to make that when we write a report to ministers, we don't just take into account the environmental information submitted as part of the inquiry process and the evidence gathered at the inquiry, but we also take into account the consultation responses and the letters of representation that have already been lodged to the Energy Consent Unit. Yeah, so what I'll do now is I'll hand over to Mr. Bray just to talk a little bit more about the parties' views on the proposed procedures.
Thank you. I just want to check that everyone is okay to continue. We've been going for just about an hour. If there's anyone who's a bit fatigued by listening to us, we could take a short break. But if everyone is content that we carry on, then I'm happy to do so. Can't see any hands flying up, so let's see if we can get into the Appendix 1. I think we would turn to. So if you have the agenda in front of you, I would turn to Appendix 1, which runs over a couple of pages. So our view at the moment is that in terms of inquiry sessions, that would relate only to ecology and nature conservation. In terms of hearings, our view is there are requirements around heritage, landscape and visual impact, public transport and conditions. We've also identified the potential for a hearing with regard to agriculture, should it be required after the submission of additional information that you heard a discussion on earlier. So that's the, if you like, the formal oral sessions that are being proposed, one inquiry topic and a number of hearing topics. We've also identified, which is further down the list, after community hearings and conditions, we've identified a number of further written submission topics. Further written submissions are questions that we set out, but we'd, in addition to the list that's set out there, we would add also woodland and forestry to that, and also private water supplies to that list. So the list in Appendix one. It's grown a little since we drafted that table. So that's a summary of what's in front of you there in terms of the topics to be covered and our proposed procedures. It might be useful to just run through the planned oral procedures as they appear. So in cultural heritage, we propose to conduct a hearing, and that will focus largely on those scheduled monuments that Scotland Environment Scotland have objected on, but also to include additional cultural heritage sites that would be identified through further written submissions. With regard to that, we note that the council have raised a number of listed buildings, for example, that they are concerned about in previous submissions. So we plan to carry out a further written submissions exercise, if you like, to hone down the list of assets to be considered in that hearing, and also for accompanied site inspections to be conducted, the number of which would be, again, the matter of further written submissions. Now, on these matters, I wouldn't mind just getting Historic Environment Scotland's view on what we've set out there.
Thank you, sir. So far as cultural heritage is concerned in Historic Environment Scotland position, as you know, sir, there are currently 25 scheduled monuments to which the Historic Environment Scotland has mounted an objection to. It would seem, with respect, that the most productive way to proceed would be to have accompanied site visits in advance of any hearing session, not least because, as Ms. Hardy earlier intimated, some of these will be difficult to access. It may also not be possible, and indeed probably highly unlikely, that you'd be able to visit all the scheduled monuments to which Historic Environment Scotland has mounted an objection. But the intention would be to collate selected highlights, if I might put it that way, of what Historic Environment Scotland consider to be the most illustrative and helpful monuments to visit. And they can do that obviously in liaison both with the applicant, perhaps also with Highland Council, and of course with yourselves. But it's thought that it might be productive to, as I say, have those site inspections carried out prior to any hearing. So far as procedure is concerned, Historic Environment Scotland would agree that there should be a hearing session to address those issues. I note also that there may be, having regard to what Mr. Mackay said, there may be an update to the cumulative baseline so far as cultural heritage is concerned, but that's probably a matter which can be picked up in any, first of all, by any additional information, with or without a capital A and a capital I, lodged by the applicant and or in any hearing statement. But clearly, Historic Environment Scotland wish to be able to respond to that updated baseline if so advised. So far as length of the hearing, as far as whether the hearing should be in person or virtual, Historic Environment Scotland don't have a particularly strong view one way or t'other, but in person, if pushed against the wall, might be the most advantageous, noting that because so much of this is a question of judgment, it may be that the discussion can be more productive if parties are in the same room around the same tables, but very much in the reporter's hands as to what they consider to be the most appropriate way to proceed. We've also given some thought to how long a hearing session would be required to address the cultural heritage issues, noting, of course, that it's not just the scheduled monuments which come under that umbrella, but obviously those are the ones which Historic Environment Scotland are interested in. I would have thought with advanced site inspections, perhaps as much as 3 days, perhaps 2.5 days would be required, noting that it's anticipated that cultural heritage will take place, the hearing session will take place the first week, and noting that inevitably logistics suggests that there's usually a bit of time taken up on day one of any hearing to sort matters out. The only other matter I'd wish to raise at this stage, sir, is that it's noted from the agenda that there's no topic addressing policy issues. Clearly, there is policy on cultural heritage, and Historic Environment Scotland would be obliged if you would indicate if it's intended at any hearing session to have a discussion on policy matters as well, because they would certainly wish to take part and indeed provide evidence on policy issues. I think I said that was the only other matter. One other issue which I should probably raise, having had some discussions with the applicant and noting the correspondence the applicant has had with the DPEA, is the question of hearing statements and rebuttals. Again, there are no firm views so far as Historic Environment Scotland is concerned. Normally one would expect just to see hearing statements lodged by all parties, and any rebuttals in quotes would take place during the hearing session itself. But if the applicant somehow envisages lodging its hearing statement and then responding by way of rebuttal to other hearing statements, again, there's no firm objection to that. However, with the caveat that it would be understood that Historic Environment Scotland would be able to fully respond to any such rebuttal. I'm not suggesting that there be a never-ending process of statements, rebuttals, counter-rebuttals, and so forth, but I would certainly wish to flag up the ability and the opportunity, I should say, to respond to any rebuttal if the applicant is permitted to rebut the hearing statement. Quite what form that response would take, I suppose, would depend very much on the extent of any rebuttal, whether it could be dealt with orally at the hearing session or whether it might be necessary to tease matters out in a short further statement. I simply can't hopefully advise at this stage.
Thank you very much for that. That's really useful in terms of what you've said about procedures. We'll take that into consideration before finalising the procedures. It might be useful to flag up just now that I think Mr. McGann, in terms of timescales, might be identifying time in advance of any oral procedures for accompanied site visits. So I think we have identified a slot for that, so we'll come on to that. So that fits in with your comments there. Matters with regard to policy we'll consider. We would certainly be doing that with regard to landscape and impact, so it may be useful to do it similarly for cultural heritage within a hearing setting. And you seem to support the idea of going out with further written submissions to try and hone down the scope of the hearing, but also the nature and detail of what accompanied site visits would look like. The geography are relatively close together, and there's no other generally concerns more to the north, but the council's got concerns elsewhere. So we felt that it would be useful to carry out some of that discussion through further written submissions in advance. So Mr. Finlay, from the council's point of view, I think you've got your hand up.
Yes, sir. Firstly, the council isn't intending to take part in any hearing session on scheduled ancient monuments, leaving that to HES. And I just wondered whether it may make sense to split the cultural heritage session into two, one dealing with scheduled ancient monuments, which HES would be involved with, and one dealing with any other matters that arise through the further written statements that you identify, which the council may be involved in. As to those other matters, the council considers it likely that a hearing session might be sensible on the impact on Fairburn GDL. That's the garden design landscape at Fairburn. There are a number of listed buildings, and there's outside of this meeting there's some liaison about that, but it may be some of them would also benefit from a hearing session, but that can be identified as you indicated. We are consider that a hearing session in person is likely to be more appropriate, and I think those are the submissions I wanted to make on cultural heritage.
Mr. Finlay, I think next with her hand up is Jackie, I think from TimeSpan, is it?
Yes, thank you. I just wanted to ask Ruth if to keep the process open, transparent, and inclusive, if there would be opportunity to attend on the site visits. Ours are very accessible, and I can only speak for ourselves, but there are many other constituted organisations along the route that have submitted comprehensive representation in objection on several areas of cultural heritage. And we, up until this point, we have had, there has been no opportunity, or in fact, we have been inhibited from attending any of the on-site assessments of the area's cultural heritage. So we would welcome the opportunity to maybe be notified of those visits and to participate verbally, and to have a conversation about the cultural heritage along Lothan, Kildon and Straths, and Strathbarora as well. The other thing is, for the council's point of view, if we're talking about archaeology that is protected, and in terms of the hearing and the EI environmental impact assessment, archaeology, and that's only a small that's only a small proportion of archaeology that will be destructed. So I do believe within the hearing process there has to be significant discourse on the impacts on unprotected archaeology. We've said this from the beginning. This is not about site by site. This is about the process, and unprotected archaeology. Just because it does not have a designation doesn't mean it is not worthy of protection. The third point I would be interested in finding out is the community consultation. I heard you say that you will listen within these meetings, the community.
Can I perhaps stop you just now so I can deal with those two? If you're going on to discuss your views on the community consultation, then that's not a matter for us today, because that's, if you like, historic. But in terms of, just to clarify, arrangements for accompanied site inspections, what would happen is those bodies or groups that express a view that they want to participate within the cultural heritage hearing, it is those participants who would take part in the accompanied site inspection, because that accompanied site inspection would be linked to the hearing session. So say, for example, it was Historic Environment in Scotland, a community council and the applicant that wanted to be involved, then it would be those three parties that would go to the site inspection. The site inspection is only to be, it's used as an opportunity for those parties to point out matters of interest to the reporters. It's not an opportunity to have a debate on site about the merits. So I thought it would be useful that I explain that first off. If a group or a party are not participating in a hearing, then the community hearings is an option whereby a statement can be prepared and submitted, and then presented to the reporters on any topic. I think not set to restrict that quite yet, or probably would. So there is an opportunity through that for those who didn't want to participate in a hearing. So I just thought I would clarify these matters first. And on your point on the applicant's consultation, was there anything relevant to the procedures that we're discussing today?
Just wanted to know from that written community statement, what is the outcome of that? Is that used among the evidence? I heard that communities would be listened to, but I didn't really hear what the impact of that would be or what the procedure is after that.
Well, the hearing statement that we would ask all participants of that community hearing process to prepare would be part of the evidence. Their earlier submissions have been made to the ECU, have been made as part of the evidence. So it's all part of the considerations going into our conclusions and recommendations. So anything that is produced as part of the hearing, written material, would be part of the evidence that we would consider, and also what you say at the meeting as well, and any answers that you may give to any questions that we have. Is all evidence. So not taking part in, for example, a formal hearing on cultural heritage does not move your ability to make your views known on cultural heritage matters. Hopefully that reassures you of that.
Can I just clarify that you're saying that there is the opportunity for organisations like Timespan who have submitted representation and continue to update that representation to participate in site hearing visits. Is that correct?
Well, perhaps I didn't explain myself. If your organisation chose to take part in a hearing that is proposed on cultural, the formal hearing, if that's the cultural heritage hearing, not community hearing, then those site visits would be linked to the participants in that hearing. Now, if those participants in that hearing, for any reason, felt that they were happy for others to come along, that may be manageable. It may not be in terms of transport and logistics and such like. But any member of the public who attends site visit who's not part of the hearing process don't say anything. They just observe. So anyone who would go along to any site visit that isn't involved in a hearing would be on an observer basis and not be able to point things out on site. Hopefully that explains it for you. It's quite difficult to manage those who are observing in terms of site visits if it's a remote site, for example. So we wouldn't necessarily anticipate that would be manageable in this circumstance.
I'll just maybe clarify one point. When we talk about point things out on site, we mean physical features. We don't mean a discussion. We don't mean point out parts of your case, just so that that's clear.
So hopefully that's explained your potential involvement there. I think Mr. Mackay from the applicant, you have your hand up next, I think. So if I could go to you.
Yes, thank you, sir. It's just to respond very briefly to some of the points made by Linda and Ms. Crawford. And first of all, to agree that a hearings procedure seems to be appropriate in these circumstances, although the applicant's view is that that should definitely be done in person. It makes it a lot easier to engage on the issues. Secondly, we completely agree with the suggestion of an accompanied site visit in advance of the hearings being carried out, and we're happy to liaise with HES on appropriate locations and an itinerary. Just also to confirm on the suggestion that there should be rebuttal statements, and that is available to all parties are participating in the hearing. It's not for the applicant's benefit. The intention that would be that would help to focus the issues for the hearing itself. And of course, if HES wants to respond to any issue identified in the rebuttal, then part of the discussion. So hopefully, sir, that assists understand the applicant's position on the topic.
Thank you for that. Looking at the remaining hands, I think Jackie from Timespan still has her hand up. Oh, it's disappeared. Mr. Heathcote, you have your hand up.
Sorry, I just wanted to reinforce the point made by others that there is quite a lot of archaeology that isn't within the remit of HES, undocumented, and we would like to draw the reporter's attention to it. Whether that's best done by flagging up there should be an accompanied site visit to Strathskiach, which could probably be fitted in with other journeys. But what I'm hearing is that we should certainly have somebody attend that hearing so that they are in a position to provide some new information and to participate in any site visits that are organised.
Thank you for that.
Can I just say something quickly? Sorry, I don't know how to put the hands up sign. I just wanted to let Ruth Crawford from Historic Environment Scotland know that I'm happy to get in contact with Historic Environment Scotland and liaise with them if they would like me to do any representations with them on their behalf for inaccessible or challenging sites to get to, because one of the main historic sites that cultural heritage that I'm interested in, as I said earlier, it is a 5-6 hour walk on foot, and if anyone involved felt that that was too much for them to walk, I certainly have extensive detailed photographic and video images, which I'm quite happy to take more of if you wanted a representation of that site, if it was felt to be inaccessible or too challenging to access. So I'm happy to get in contact with Historic Environment Scotland to just speak more about that.
Yeah, thanks for that. Any liaison that is going on in the background between parties not necessarily matters for us unless we're formally asking for that. But I'm sure representatives of Historic Environment Scotland noted that. I think that's a useful discussion on cultural heritage. It will frame and probably adjust our final procedures, I think, and we're hearing, I think, loud and clear that in-person hearing be best. For landscape and visual impact, we've set out there a requirement for a hearing. Also, further written submissions with regard to clarifying what might be the most appropriate arrangements for carrying out site visits, accompanied or otherwise, to residential properties. We've, as Ms McCallum has indicated, we've carried out extensive unaccompanied site visits in connection with landscape and visual matters already, in light of all the submissions that have been made. But we do feel that there is a need for a hearing on specific matters, including policy, which has been mentioned with regard to cultural heritage. But we do think there is a role for an exchange of further written submissions on narrowing the scope of properties to be visited and the arrangements for that. The likelihood is that we would look towards the applicant to coordinate that, to visit a number of residential properties, a number of which we couldn't get too close to because of private roads and such like. We were out and about. So, and in respect of those unaccompanied site visits, we would anticipate that those would be in advance of a hearing, and if you like, the evidence gathering for residential visual amenity will be focused on the site visits and wouldn't necessarily be a topic for the hearing, because what's important in that is that we actually get out to see more of the properties. So that's what we propose for landscape and visual impact hearings, certainly a day and maybe more. The nature of the draft scope is set out there. I think, Mr. Mackay, you want to come in first.
Yes, sir, and I think it's partly simply to remind Mr. Finlay that he has a difficulty with availability on the 27th of November, as I understand it. And it seemed to the applicant that what might make sense is for landscape and visual, the hearing session for landscape and visual impact, that could take place on the first day of the inquiry, so that he's available for that session, rather than it being the second, which might end up clashing with his other.
Perhaps I could turn to the council, but then just now I know that others do have hands up, but Mr. Finlay, in terms of a procedure for landscape and visual impact, any thoughts on yourself, including the kind of programming that Mr. Mackay had mentioned?
Well, I'm very grateful to Mr. Mackay for mentioning that. I'm quite happy with your suggestions for landscape and visual. Consider it should be in person, a hearing in person, and yes, if that could be on the first day of the inquiry, that would be we'd be grateful. We could first day of either week. It could be the first day on week 2 either as well, I'd be grateful for that. Thank you.
Mr. Kelly, I think you have your hand up.
Thank you, sir. Just as an aside, well, 2 points. Just an aside, I think to be still thinking of oral evidence sessions in November isn't going to happen given that times, but we'll come on to that. What I was going to say was the main point I wanted to ask about was policy. You seem to be looking for policy issues to be raised in the further written submissions and hearing statements for each individual topic. Would it not be better to have single policy hearing session preceded by a single written submission or hearing statement on policy rather than to divide it up, especially since we know that ministers are wanting to look at matters in a more holistic way? I just wonder if an overarching policy session might be a better approach than having policy addressed under each individual topic. Thank you.
Mr. Kelly, we'll certainly consider that. Does the applicant or the council have any strong view on that? What we're proposing is that certainly landscape and visual matters and likely, potentially, cultural heritage, at least to have that policy element to discuss as part of those topic hearings. But Mr. Finlay, I think you've got your...
Yes, I hear what Mr. Kelly says, but I think from Highland Council's view, it'd be sensible to deal with the policy aspects of those matters. For instance, cultural heritage as part of a cultural heritage session. And then, for instance, Historic Environment Scotland wouldn't have to come back on a separate day and listen to policy on deal with policy on scheduled ancient monuments, but then deal with policy and sit there whilst policy and a lot of other matters are being dealt with, which they've got no interest in. So notwithstanding what Mr. Kelly said, the most efficient way is the way that I anticipate you're proposing it at the moment.
Thank you. Mr. Mackay?
Yes, I would support that approach, sir. Indeed, in relation to each of the hearing sessions that you're going to hold. So that would include any policy issues related to ecology. So I agree with the approach set in the timetable on the submission by William Shrimstable.
Ms. Crawford?
Thank you, sir. It was just to acknowledge the point made by Mr. Finlay relative to Historic Environment Scotland's position. Its wish to attend this inquiry is purely related to cultural heritage, and while it'd be very interesting to listen to a holistic, wide-ranging policy discussion, it may not be the best use, at least as far as Historic Environment Scotland is concerned, of its time and resource. So our preference would be to have policy addressed in the hearing session on cultural heritage. And no doubt, of course, you, sir, will be able to, when providing your report, be able to consider policy as one would expect in the holistic manner which Mr. Kelly has urged upon you.
Thanks for that. Well, we'll carefully consider what everyone has said in those matters. And in some of the matters around a need and our further written submission topics, it may well be that some of those may cover a wider policy matters in any event. We'll consider those carefully. The other hearing that I was just wanting to flag up before some comment comes in is on traffic and transport. And in summary, what we would propose is a written submissions, a exercise, and it may well be targeted towards the council to assist in narrowing down the scope of a hearing, but we do consider that a hearing is required. There's been extensive comments and representation on transportation matters, and the council's submissions have been quite extensive as well. So we do think that there is a need for a hearing, but we do consider that an exchange in written submissions in advance will help focus that. And there's the question of whether in person or virtual there as well. But perhaps if I could turn to the council first, does that sound reasonable that we're proposing a hearing, but an exercise to narrow the scope of what the critical matters are? Mr. Finlay.
Yes, although the extent to which the council will actually be involved in those hearings will keep under review.
Well, and again, we'll emphasise that participation in all of these procedures is something that you will be able to kind of sign up to after this meeting. So after hearing what we have said and reading what we put in the note of the meeting, there will then be the opportunity for those to decide whether they wish to participate in any procedures. Mr. Kelly.
Thank you, sir. Looking at the council's position as determined by the two committee meetings that first looked at this application, and anticipating the next two meetings, I had understood that the council were looking for significant amounts of additional information. Sorry, small a, small I, additional information on traffic and transportation issues. And we were expecting to see that, including traffic routing and volumes. The other aspect is my clients are quite clear that they will be looking for, requesting accompanied site visits in relation to traffic and transportation matters, especially addressing issues raised in the NPAC consideration of the application. Bonar Bridge and the road through Bonar Bridge is one particular example. But again, we can respond in due course in line with what you require, sir, and indicate where we would be looking for accompanied site visits on traffic and transportation matters.
Thank you for raising that particular matter, Mr. Kelly, flagging that up to us. Mr. Heathcote, you were next.
Just to say that we also would like to point out certain traffic obstacles on a company site visit. We were proposing to produce a short further written submission on general transport matters, but almost certainly transport matters are going to come up in community hearings and will be focused on specific features if that is going to work for everybody.
That would certainly be an option. If participants are not involved in the specific topic hearing, the more formal hearing, then there would be the opportunity to raise those matters at the committee hearings and submit a statement. Only site inspections would be to the topic-based hearing.
Okay.
I think that's me for hearings. You've got a couple, I think, to go through, Mr. McCallum.
Yeah, I just want to say a little bit. Appendix 1 was drafted prior to me having any information from the applicant on their proposed additional information. So initially, the appendix sets out the sort of topics that considered required further procedure. Having heard from the applicant on their intentions for additional information, my view is that only the upper part, which is effects on the flow country, the Shields and Peatlands SSI, and this Keithis and Sutherland Peatlands Special Area of Conservation and Ramsar site, would be subject most likely to still inquiry sessions. But depending on what we receive, I'm prepared to sort of like consider whether a hearing would be appropriate. But initially, I think given the technical nature of information that we're likely to receive, I would prefer to deal with that as an in-person inquiry. But I'm welcome to parties to give me their views. I would separate out the effects on the Nova and Morangi forests, special area of conservation, and in particular the effects in Capercaillie. Again, that's, I think, initially likely to be subject to potentially an inquiry, but I'll be prepared to hear parties' views. The bottom section, from effects on the Caitha Sutherland peatlands SPA in terms of ornithological effects, and section below, I'm pretty satisfied now that we're likely to be able to deal with those by further written submissions. So could I initially just seek the applicant's view on that?
Yes, thank you, ma'am. I can understand the instinct that is pushing you towards the suitability of full inquiry for the first two issues you've identified. However, I think it's fair to say that the applicant and Nature Scott do anticipate being able to at least agree some of the essential facts that will be of relevance to that particular issue. We envisage that the debate is more likely to turn around issues of opinion. And there's a number of advantages we consider, and the applicant considers, that attach to hearings procedure more generally. I'm thinking of things like accessibility, allowing all parties to participate, having advance notice of the issues. It's not like the preparation is any less intense. All issues should be available to all parties. Continuity, I think that's a particular issue here, ma'am, if I may say, because an inquiry procedure has a slight disadvantage that you hear from individual witnesses for a period of days. Whereas for a hearing session, you have effectively an agenda and you can discuss the topic, and all relevant evidence relating to that issue can be ventilated and discussed and debated right there and right then. And I think that might prove to be quite important in relation to the impacts on blanket bog, understanding the different elements and how they feed into the overall discussion. So there's an attraction from the applicant's point of view from that respect as well. Another main issue, of course, is one of efficiency, and just really getting to the heart of the matters as quickly and as efficiently as possible. And again, experience suggests, for example, the Kirkson Wind Farm inquiry, where Mr. Liddell was the reporter, and that hearings procedure can actually be really appropriate, even where relatively technical issues are being discussed. And just with that in mind, I would also observe that based on the indicative estimates for the hearings on landscape visual impact and cultural heritage, that's likely to take up most of the first week, probably all of the first week of the inquiry, which means that the second week of the inquiry needs to deal with all of the ecological related issues that are being heard in oral evidence, and all the other hearings and other issues. I'm sure we'll come on to talk about the conditions session in due course, for example. So there's a practical imperative to complete this inquiry, the oral sessions pre-Christmas. And again, from that point of view, it seems to the applicant that there's a real attraction to hearings procedure. So those were the main observations that I would make on what you've said so far. I agree with your indication that hearing might be appropriate for the Movar Morangi Forest SPA, and I agree with your position in relation to written submissions for the other issues.
Thank you. Nature Scott, who's got their hands up? It's very difficult to read these screens.
This is Charlton Woodland for Nature Scott. Thanks very much, ma'am. Just to endorse and confirm what Mr. Mackay was saying for the applicant, although there is no formal joint participation by Nature Scott with any other party, we are very much engaged in behind-the-scenes discussions with the applicant and other relevant statutory consultees. And for that reason, and also because a lot of ornithological issues are being dealt with in the context of a kind of hearing plus for the Beauly to piece ahead proposals, we're hopeful that all the ornithological issues might be sufficiently addressed through further written submissions. That is because the hearing plus, as I refer to it, approach being taken in the Beauly to Peterhead matter involves questioning of other parties as well as ongoing background discussions. The hearing for that is scheduled for the 21st of August, which I'm conscious will be after the issue of the pre-inquiry meeting note, but it does fall before the 1st of September, which, as you kindly pointed out, is the date for reconfirming participation in further procedure. So we would propose to reserve our position on that for the time being and confirm by the 1st of September, noting that at this juncture we have a preference for further written submissions for all ornithological matters in this case. As far as the blanket bog and peatland habitat issues go, Nature Scott agrees that site visits in advance of any oral session or further written submissions would be useful, and they've provided some indicative availability for those. However, in terms of the proposals for format for dealing with blanket bog and peatland, again, initially further written submissions might be appropriate, or further written submissions used to cut down what is covered by a hearing session. If the reporters consider it necessary to hold a hearing session to deal with bog and peatland, Nature Scott would request that that be a hearing attended in person rather than virtually.
You mentioned the possibility of accompanied site inspections, and that's something I was going to ask the council about. We hadn't proposed any site inspections for ecology, principally because it did seem to be more of a difference in opinion in terms of how you apply, if you like, the methodologies and the principles, rather than a disagreement about the nature and quality of what we would see on the ground. So that's why we hadn't identified any site inspections. Would you be of the opinion that they're necessary or helpful?
As far as we're concerned, no, that's primarily going to be a matter for Nature Scott. I think that we're not anticipating taking a significant role in this session in any event, leaving that for Nature Scott. We may have more to say about ecology matters by way of in the conditions session. In terms of any site visits, that'd be a matter for primarily for Nature Scott, yourselves and the applicant.
Their initial thoughts had been similar to what had been set out earlier, is that policy issues in relation to habitats and ecology would be wrapped up within that topic rather than a separate policy session. Would that present a difficulty for the council if we did it that way?
No, it shouldn't do. And again, we'll see, depending on the issues, the extent to which the council needs to attend, but that would, in line with my submissions earlier, be a sensible way forward.
Okay, thank you. So really then, if I can go back to the applicant, do you have a specific view then on both the need for site inspections and also the how we address policy as part of the ecology and ornithology session?
Yes, on the policy aspects, I agree. It makes sense to deal with it during the course of that hearing, towards the end probably. And on site inspections, I really would encourage you to go to the site. It's of course not easy walking on a blanket bog, and there may be practical issues to consider about the timing. But there's a lot to be learned and a lot to be gained from a site visit. In particular, sounds like a very technical issue on paper, is actually a practical issue on site. And there's lots of different aspects that certainly the applicant's team found really helpful to explore site visit. So I would definitely encourage you to allow for company site visits.
Would that be to see specific locations? And how do you envisage that actually taking place, because I mean, we've been up there, we've driven quite a lengthy route, we've viewed the designations on the ground. So what we were really just trying to get to the bottom of is what exactly was it that we really needed to see on the ground. Not trying to be difficult, it's just that we need to understand what it is that we're expected to see.
Yeah, I appreciate that. And of course, the applicant can suggest specific locations that gain an understanding. The depth of the peatland, the routing has been carefully chosen in that area, potential for micrositing possibly. You'll also be able to look at examples of mitigation that's happened, look at better appreciation of the different quality of the habitats on site, a number of related issues, which, as I say, are technical paper, but is site. So yeah, in terms of the precise locations, the applicant's team have carried out pretty extensive site inspections already, and we can provide a list that you might find helpful.
Yeah, so it sounds as though there's already been a good bit of a liaison between yourself and Nature Scott. So what I would suggest then is that's something that we'll give consideration to, but also if you could have a think about it in terms of what is appropriate and what's manageable. I do have to say that you need to take into account I do have limited ability to walk on that sort of ground. So it would need to be something that is accessible for me.
Noted, and we'll bear that in mind, of course.
Yeah.
Mr. McCallum may send a number of substitutes to.
Yeah, I think given the volume of site inspections, given that we've both seen the kind of the whole length, it was never our intention that we would all, the 3 reporters that were assigned would go to all the site inspections. We'll choose the ones who, appropriate to the subject who'll turn up. It's just that unfortunately, due to an injury, I'm not capable of walking any distance over ground like that. So I would need to have a good think about what it is we need to see and what arrangements can be put in place, and then decide on how we would do it. We'll come on to the timing of things and whether it's practical to fit everything in to the timing we've got. I don't know whether we want to discuss any more about the other topics we've got in Appendix 1. Or...
I think we're probably. I don't think there's necessarily a need to go through the other written submissions again. We added a couple of topics in terms of woodland and private water supplies, and we'll discuss. We'll go on to discuss a phasing of those further written submissions in terms of timescales, so they won't all be flooding your inbox at once. I'm quite content. We've had a good discussion on matters. We discussed agricultural matters earlier on with regard to hearings and such like. So, Mr. Kelly, though, before we move on, we'll give you an opportunity.
Can I just clarify one aspect of the community hearings, and it relates to differential approaches I've seen in other cases. The clients that I have opted in.
I'm going to stop with now, Mr. Kelly. Because we've got a specific item on community hearings coming up where Mr. McCallum will go through all of that and set out the approach. Sorry to interrupt mid-flow, but there's a specific item on that because we know that's important to spell out what's involved, Mr. Kelly. Are you okay to come back at that point?
Yeah. I thought we were discussing the evidence procedures in Appendix 1, and I was going to raise it under Appendix 1, but if you're saying I can deal with the matter later, then that's fine. We'll deal with it later.
We're going to have a good discussion on that later, rather than try to shoehorn it in just now. But before that, I just want to kind of reiterate, and you've heard it already, that we'll be asking for people to reconfirm their intentions. There'll be a form to fill in for parties who've already opted in to confirm which procedures they want to participate in. That's very important. That's going to be 14 days from the note of this meeting. So when the note comes out, it will be accompanied with a form which you will be able to fill in. I would fill that in after carefully reading the content of the note. Just complete the appropriate parts of the form. Any instructions that are given, please read them carefully. It's important that you select the procedures that are relevant to you and that you intend to actively participate in. If errors are made in either way, you don't tick a certain box or tick too many, that gives an extra burden for everyone, really, in terms of managing the process. If you don't reconfirm, then we would assume that you are opting out of those parts of the process. And if you don't reconfirm, you won't hear any further correspondence from us, that you'll be resting on your existing submissions. So that's a few notes in terms of how to participate in those procedures that we've just talked about. And while participating, I think it's useful to think about opportunities for joint participation. We appreciate the efforts that have been made so far. Today we've got Mr. Kelly and Mr. Heathcote talking on behalf of a number of parties, which has been really useful for our discussion. That may be an approach that is taken further as we move on and parties opt into particular procedures. So we would encourage the selection of a limited number of spokespersons in informal oral processes, because it does make it easier to manage and a better opportunity for those to make their points if they're grouped together. I think we've heard probably fairly loud and clear with regard to whether procedures should be in person or virtual. I think it's fairly unanimously in person, unless anyone is particularly keen on virtual hearings. We might discuss that under conditions, but it seems as if most of the parties who have spoken so far would prefer these matters to be dealt with in person for oral procedures. Mr. Kelly.
I have a request from my clients to ask if it might be possible to have hybrid procedures so that people could join virtually into a hearing session. It's just to help with the logistics and costs for community groups. It's not something that we're saying has to happen. It's just a request that some consideration is given to whether a hybrid approach might be possible.
Once we understand the number of parties that intend to participate, we could consider that. However, they are particularly difficult or more difficult to set up from our perspective in terms of our resource. May or may not be able to facilitate that. There's differing views on how effective that is sometimes. If there are for example, if there's a large number of participants who are planning to participate online, then it may be more appropriate to conduct all of the procedure online. So I think we'll take that into account once we know the number of parties that are to participate. I think Nature Scott are next.
Yes, thank you, sir. In terms of the preferences for hearings, just to clarify that Nature Scott, in respect of substantive hearings on technical issues, would always prefer an in-person hearing. However, when it comes to conditions, and I'm sure you'll come onto this in due course, a virtual hearing would be the preference. And if I might take the opportunity as well to clarify on the site visit point to do with peatland and bog. Although Nature Scott, of course, is happy to accommodate whatever suits the reporters best, and thinks that site visits can be useful, they are not essential from Nature Scott's perspective in this. So thank you very much.
Thank you.
Ms Crawford for Historic Environment Scotland.
Yes, thank you. It's just to pick up on the format of the hearings, and I don't know if we're going to come on to discuss conditions separately. It's presently put in the timeline as being for a virtual hearing for conditions, and that would certainly be Historic Environment Scotland's preference, noting the time of year and noting this will be taking place after its involvement in the cultural heritage hearing session, with all the logistics and meteorological difficulties that there may be going further north at that time of year. As I say, I don't know if you're coming on to discuss the condition session later on, but I also noted what Mr. Kelly suggested relative to the possibility, but that may be an impracticability, of having hybrid hearings, and maybe for conditions, some consideration could be given to that if, for example, the applicant considers that an in-person hearing for conditions, and you agree with this, is more appropriate. But certainly Historic Environment Scotland's preference would be to have a virtual session for conditions. Thank you.
Thank you for that. That's what we had noted down, and there is an opportunity to discuss the conditions hearings. Actually, I'm going to squeeze that in towards the end. Certainly on hybrid, what I would also say that whilst it may be convenient, we'd be looking for a strong justification, if you like, for that. Where hybrid has been used before is where people have been unable, for a range of reasons, through disability or otherwise, to participate in that way, or they've been abroad or such like. But it may not be acceptable just because it was just slightly easier. So I'll put that caveat on the consideration of hybrid. But the general view that we're hearing is that in person is particularly useful. Before I go on to locations, Mr. Mackay.
Yes, just briefly, sir, in relation to the conditions, there may be practical reasons why it makes sense to have a virtual hearing for conditions. However, I suppose one option might be for the conditions to form part of the agenda for each of the hearing sessions. That we have the advantage of the main parties being present and people being there to discuss the issues as part of the hearings procedure, which again should help with efficiency.
Thank you for that. It's unlikely that we will be able to do that much preparation in advance to deal with conditions as well as everything else in the hearing. So it's unlikely that would be manageable, Guy, from our point of view. And there's quite a lot of focus has to be given on to hearings on conditions separately. So I think that would be unlikely. In terms of location for an in-person hearing or inquiry, my preference is that one location over the 2 weeks, in terms of setting up equipment and having equipment installed, for the whole week, in terms of a video conferencing facility would be preferable. We've had a couple of comments with regard to suitability of specific locations, but we believe through email correspondence that was sent to us that the applicant had been discussing venues with the council just a few days ago. So perhaps I could ask the council, perhaps as a local authority for the area, to indicate any preference for a single geographical location, potentially midway. Mr. Finlay.
Yes, so just before I deal with that, could I revert to the issue of the conditions session? Certainly my experience is that mainly in-person session would be preferable, but a blended session of the type proposed by my own friend Ms. Crawford may be just as acceptable. There will be a lot of conditions which, for instance, her clients won't be interested in, but there will be some which they are interested in. But there'll be a large number of conditions, and our experience, or my experience, is that that's perhaps better dealt with in person if possible. As as to venue, there are discussions still going on with the applicant. So the council's initial view was that Beauly might be a sensible location. I know the applicant is proposing Dornoch, but those discussions are likely to continue, and it's something that we can revert to you on, if possible, say within a week, as to the most sensible place for those.
I think for today, I'm happy to hear from the applicant if there's anything to add to that, but I would certainly like to listen to others in terms of their thoughts. Mr. Mackay, anything to add to what Mr. Finlay has said?
Yes, there have been a number of potential locations, and obviously the applicant has taken into account things like travel time, and also the size of the venue that's availability, and things like practical issues like strength of Wi-Fi and so on. And at the moment, the best option would appear to be the Dornoch Station Hotel in Dornoch. Obviously, subject to others' views and your own views, sir, but that may be a practical option. But as Mr. Finlay says, we can update you in relatively short course if there are any other particular venues that come to mind.
Mr. Kelly.
Yeah, I think it's important to include the community interests in these discussions. It's not, the public inquiry is not a private affair between SSEN and the council. So we have a view as well. My clients have suggested Strathpeffer as a possible location, or Dingwall, which has been used. There's I don't know whether it's still open or not, but there was a large council office in Dingwall. I think going forward, I would just ask that the discussion of venues is also passed by myself, so I can take views from the local community. But as a matter of principle, I would agree. I would agree with the concept of having a single venue for the 2 weeks. That makes a great deal of sense. Thank you.
Anyone else on the call?
Sir, can I just say that as a Beauly resident, I can confirm that Beauly is the most accessible venue out of all the ones mentioned. There's a very fast train that is 10 minutes from Inverness to Beauly. Strathpeffer, there's a more lengthy bus involved. Dornoch is completely out of the way. I would certainly recommend Beauly, and can I also say that Beauly is going to be one of the areas that is going to be the most hardest hit by these SSEN plans. So there's certainly the the area where the community is most active and would be most keen to participate. So as far as convenience and also community participation, I would like to strongly recommend my hometown of Beauly. So that's all I've got to say. Thank you very much, sir.
I mean, we're obviously conscious of the geography and the matters raised by Mr. Kelly about it. It's a public local inquiry. It's not solely just about those participating in it. There may be those observing and good people from further north might find it more difficult to get down to Beauly. So certainly a location which has got a bit of geographical sort of parity across the line is our favoured position at the moment. We'll consider what has been said, but certainly at the moment, I don't think we would have any particular problems with what the applicant is suggesting. Ultimately, it would be a matter for ourselves to determine with regard to the range of facilities there, because we do need certain requirements and such like. So there may be venues that are just not suitable for the scale of such an event. So we'll hope to try and make a determination on that fairly soon. And it may well be that we ask for submissions on that by the 1st of September, when people are indicating that they're going to be participating. But at the moment, in light of what has been said so far, I can see other lights coming on, is that the opportunity for Dornoch and perhaps Strathpeffer, that provides easier options for those impacted across the length of the line. But I think there are a number of hands up. I think Carol, you have your hand up.
Hello there. As a representative of a very small community group in the far end, up in Helmsdale, we would find Beauly very difficult to get to and would want something a little bit more easy to travel to. And I feel that there are a number of community groups in Northern Highlands that may not want or mainly be able to travel so far south. And I concur with what you said, sir, that we do need to look at this geographical situation with regard to the smaller groups. Thank you.
And Jackie from Time Span, I think you've got your hand.
Yes, I just want to make the same statement as Carol. Beauly isn't accessible for majority up north. We would obviously look at other venues, as you mentioned, Dornoch. I would also say as well that maybe, I don't think it's really dependent on, I think all areas of the line are impacted heavily by this proposal. So I think it's just really looking at geographics and not discluding representation for where they are located. Thank you.
Thank you for that. We will come on to talk about locations for community hearings. That's something separate, so please bear that in mind as well. But I think we've had a good discussion on that. If you need anything else on that, no, okay. We have also discussed accompanied site visits, because I was going to discuss that. But I think we've had a good discussion on residential, visual amenity and cultural heritage site visits, and that there'll be further written submissions. And that those particular site inspections would be beneficial to be in advance of hearings. So I don't think I've got any further questions for the participants on that matter, other than to reiterate that unaccompanied site inspections are part of the evidence gathering for this inquiry. We've had extensive unaccompanied site inspections, and we plan to have more of those. So just because certain site inspections are not accompanied, i.e. by other people in the procedures, it's not to say that we've not visited certain places. And we'll conclude all the our conclusions and decisions on these matters in the note of the meeting, I think. And it may well be useful now to hand over to Law on Community Hearings.
Appreciate that this is taking a bit of time, folks. We do intend to take a break, but I think what we'd like to do is just deal with the next two items of the agenda first, unless anyone's got any objections to that. Mr. Heathcote, you got your hand up. You're on mute again.
It's basically just to say on the site visit subject that the community councils I'm speaking on behalf of have put together quite a detailed itinerary of things that we would like you to have seen. It's probably best if I send that to you by email and you can comment on, yes, that's a good idea, we've been there already. It's not the appropriate thing, I think, to discuss in this meeting. It would take far too long.
What I would say on that is that unsolicited correspondence is not something that we would encourage as part of the inquiry. So if we are looking for information from groups, then we would be asking for that. We don't ask for unsolicited correspondence. You may simply be faced with an email saying, "I'm sorry, we can't take that into account at this moment." However, on the subject that you raise, I know that a group had submitted an itinerary. A community group had submitted an itinerary as part of the submissions, and that was very useful in informing our initial 453 miles of mileage in the car, excluding any walking we did. So that submission that was put together, I think it might have been a community council, was quite instructive. So we have kind of taken that into account in our initial site visits. But I think the message is please don't be sending in correspondence to us that isn't asked for, because we're not able to kind of deal with that. It's really just the formal procedures that we would be seeking it for.
Yeah, well, this is why I'm asking, would you like to receive this information? It's not anything to do with making the determination, it's just to make sure that you as reporters are adequately informed.
Well, I think we've seen what's been submitted before and we've used that, so we wouldn't be looking for an additional submission on site inspections. Certainly, if you're involved through hearing statements or any of the other further written submissions, if there's anything particular that you'd want to raise, then you could do it through those formal procedures that follow, but not a specific list of places to visit at the moment.
I see Jackie from Timespan's got a hand up.
Sorry, I forgot to take it down. I'm fine.
Oh, that's okay. Okay, is everyone happy for me to move on to community hearings briefly then? Yeah. Okay, so I just wanted to explain a little bit more about what our intentions are. And obviously we're aware of what's happened in the other two ASTI cases, but we just wanted firstly just again to reiterate that opted-in parties who wish to take part in a community hearing must respond within the 14 days of the note of the pre-inquiry meeting confirming their intention to do so. And if you wish to attend a community hearing just simply to observe and not to talk, then you don't need to confirm that. So the arrangements for the community hearings will be confirmed in due course and will take into account both the number of confirmed participants and suitable geographic locations. At that point, I think, again, what we'd say is that should the community councils have any thoughts on potentially suitable venues for the community hearings, then we'd encourage them to discuss that between themselves and to email any suggestions from their spokesperson to the DPEA. And I'll give you contact details later. But yeah, we're not encouraging everyone to let us know. But yeah, if those representing the community councils could give us their thoughts, we think that would actually be helpful in that respect. So we propose that the community hearings will be in person and that we will address the timelines for those when we get to the next agenda item. And I said earlier, we think they're probably better suited to the members of the public who've opted in because the sessions are less formal and the requirements placed on those participating are actually much less onerous. So although some parties might consider they want to participate in the topic-based hearing sessions, then we would emphasise that we just don't want to hear the same evidence twice. If you choose you want to do both, then you need to be given as separate evidence to both. It's likely that the requirements for everyone participating would have to give us their written statements in advance and that those wouldn't exceed probably around 1,500 words. The amount of time allocated to each speaker has in the past generally been 5 to 10 minutes, but we'll confirm our arrangements for participants once we know how many we're dealing with and what the geographic locations are likely to be. We just want at this stage for people to tell us if they specifically want to speak or not. So we'll confirm that in due course, and what we will do is once the parties who've elected to take part have let us know, we will issue a guidance note for everyone who's going to be there on the day. So just briefly, again, we want to touch on agenda item 6 timelines before we take our break. So
sorry, can I come in here?
Yeah, sorry.
I was told earlier I could make a point. So this agenda item. There's been some confusion over the opt-in process. I have my clients, apart from one person, are groups. I have opted in the groups. Members of those groups will want to speak at the community hearings. Are you saying that by the 1st of September, each community council and each group has to know who is going to speak months later? or is it sufficient to opt in the group and then confirm the names at the time or in advance of the statements being produced? That's the first point. Then we can come on to venues later.
Totally understand the difficulties that presents, but it also means that if we don't know how many people we're dealing with, then we can't select appropriate venues. So we need to know numbers. Now, the only way of doing that is to do it through this opt-in process, and it gives people only 14 days from now, or sorry, from when we issue the notes, so three weeks from now, to tell us whether they want to speak at a hearing or not. Nothing to stop people saying they want to speak, and then if they choose to withdraw for one reason or another, that's fine. But I think we need to know the numbers that we're dealing with, Mr. Kelly, because you could say that we've got one group or we've got half a dozen community councils, but if each one has 20 or 30 people, then we can't manage the process. We need to know. So I know it's not ideal, but it's what we've got to do to be able to figure out where we can have them, how we actually proceed. We have given this lots and lots of thought as we've reached this stage in the inquiry, and we feel that's the only real way that we can actually manage it properly. So it would mean that individuals who want to take part, we're going to give some consideration this afternoon to the form that will go out to parties, because the form will set out which hearings people want to take part in, or if there's an inquiry session they want to take part in, and the community hearings. What it won't do in this occasion is say the number of community hearings or the venues, because that proved too difficult last time with other two ASTA cases. So what we just would like people to do is tick whether they want to take part or not. I'm not sure whether or not we can refine that a bit more in terms of saying whether or not you will be represented by a spokesperson, whether it be yourself or Mr. Heathcote. That might be something that we can draft into the form, but I don't think there's any way around us not knowing, how many people are going to turn up.
I think we would want to know the numbers because what does provide a difficulty is a week before the hearing statements to be in. If we're told that 10 people are going to speak on behalf of one community group and there's another 8 groups speak, and it becomes difficult in terms of fairness, in terms of allocation of time across the hearing. So I think the critical matter would be who's opting in and the numbers. We assume one person per opted in, unless we're indicated otherwise, and it would likely then be a matter for us, our discretion, to limit that number in order to fit within the kind of broad timescales that we have.
We've no way of knowing at this stage how many people want to take part in a community hearing. It's been quite variable in the previous two, so that's really why we need to get a heads up on what we're likely to be facing.
The individual opt-in, there's a problem with the individual opt-in process you're talking about, and that is in setting up the inquiry, not, for example, I take Community Council, I take Halkirk and District Community Council. Not every member of that Community Council was contacted by the DPA and asked if they wanted to opt in. The Community Council opted in on behalf of its constituent members, and it was the Community Council who was contacted over opt-in, not all the individuals. Now, Mr. Bray has raised an interesting point, which I think is a good compromise. By the 1st of September, I could certainly give you a clear statement as to the number of speakers we would wish to have at each community hearing session for the groups I represent. It would be almost impossible to have individual names at that stage, but I do understand the issues you're raising, and therefore I would be perfectly happy to commit to giving you numbers of people for each of the hearings, the requested hearing sessions, because yes, you have to be able to organise it, and I fully understand that. But trying to give you a precise list of names by the 1st of September is, I would suggest, almost impossible. Thank you.
It's very difficult. I suppose what we also need to cater for is there will be potentially some individuals who are not going to be represented by Community Council, and it's how we capture those people.
in terms of the time allocation as well, any particular.
Yeah. I mean, for the people who are listening in today and are not actively speaking, should be all the people who have opted in already, right? So in theory, the maximum should really be 90. In theory. All we can do is try and see if we can work out a way of refining the response form.
And I think it might be useful to get, before we bring anyone else in, is just a general handle, if you like, on geography about locations, because we may ask that in the form as well in terms of your geography, so that it may well be that splitting over 3 locations, maybe a maximum of 3 locations, over the number of participants by geography, would be the right way to do it. However, if there is a limited number of participants, it may well be useful to have it in a central location, one event, but it may be more sensible to have it over 3 or over 2. But what we didn't want to do today was impose, if you like, a single or 2 locations or 3 locations without knowing the willingness of participants to be involved in this. So we'll want to take that judgment a little bit further down the line. But it might be useful to hear any parties, or if they have got any views on the location of community hearings, because I think our discussions have been so far that we would want to have them in places that facilitated reasonable, easy access to those who wanted to participate.
So if we were just before we move on, I was just going to say, if we take a similar approach to has been done in the 2 other ASTIs, then we would be trying to locate the community sessions in spots along the line where we felt as though people were equally represented. So perhaps either end of the line and in the middle. Not giving any commitment to that just now, but we just feel as though it's appropriate to try and capture as many people who want to participate as possible and make it easy for them to attend, because I think it's going to be very difficult to do community hearings without doing them in person.
Madam, I'm extremely sorry to interrupt you. I'm terribly sorry, but can I have permission to leave? I'm actually on holiday at the moment and I have a train to catch in an hour. And I can't actually stay any longer. But before I go, can I just make you both aware that Beauly does have a very, very high number of OAPs. And I know the lady from up north said that it would be very difficult for a lot of people up north to travel down to Beauly. That is actually, that works both ways, because there's a very, very high OAP population in Beauly, and a lot of those people would possibly find it very challenging to travel outside the Beauly area. So can I just leave it on that? And I will make sure that I reconfirm my involvement for the meeting by the 1st of September.
Thank you very much.
Okay to go then. Yeah. Thank you.
Thanks very much. Mr. Kelly, you still get your hand up, yeah.
Thank you, ma'am. Just on the question of venues for community hearings, the submissions I have from my clients have asked that you consider community hearings at Halkirk, Bonar Bridge, Strathpeffer, and Beauly. So from my clients, that's 4 suggested locations which they feel fairly covers the length of the line. Thank you. That's all I wanted to say.
Yeah, that's very helpful. Thank you very much. Mr. Heathcote.
Would just like to add that it's quite difficult for us to do any coordination of responses and make sure that people have understood the requirement to stay in touch to participate in community hearings. But following up what Mr. Kelly has said, the list of places that we've come up with is Halkirk, Bonar Bridge, Brora or Golspie, and Strathpeffer. So that's 4. It's actually quite a long way and not a great road between Brora and Bonar Bridge. Thank you.
Thank you very much. Thanks. Yeah, just on the, I know you're saying it's difficult to stay in touch. So what we'll do is the note of the meeting will be published on the DPA website, but the webcast is available to view on our YouTube channels. So if you point people in the direction of both of those, then hopefully that'll assist in getting the message out to people who want to participate.
And all those who have opted in, the 90 or so, will receive a copy of or will receive notification of the note of the meeting. Ms. Kelly?
Yeah, sir, you'd said you were going to give some thought to the format of the opt-in form to be completed by the 1st of September. It would certainly be convenient if I could submit a single form for all of the speakers that I'm going to try and name, rather than be having to ask every individual to submit a response form to you. I don't know if that will be possible, but certainly it would be much more administratively convenient if I could do that for everyone via myself, rather than about 20, 30 individuals having to return a form to you. Thank you.
Thanks very much, Mr. Kelly. We'll give that some thought. I don't know whether Mr. Heathcote is of the same view. I know that you're representing a number of community councils, Mr. Heathcote.
Yeah, I will obviously have to confer with them, and I'm sure that there will be at least one person from each community council, and probably rather more. But at the moment, I don't know the answer to that question. My own community council is meeting tonight, so I'll get some feeling. I don't know if my colleague from Strathpether sitting next to me has an immediate view on how many there might be.
Yeah, I would have thought there could be one or two from mine as well, but I would just like to reinforce the point Ian Kelly's made, that providing numbers as opposed to names, it would be much more manageable.
Yeah. Yeah, so I suppose people who don't want to be represented by a community council and want to speak on their own could confirm their name, but anyone who's happy to be represented, we could just have an agreed number. Or a suggested number. What were you having?
I'm aware that there are people in my community who know much more about certain topics than I do, and I would rather they spoke on their own behalf rather than I tried to grasp it and present it for them. I think that would be more effective for everybody.
Yeah, no, we totally understand. We haven't really mentioned like the timing of them. Part of our issue is getting from one place to another as well across a whole line in a limited number of days. So we haven't said whether there'll be just a session through the day or whether there'll be any sessions in the evening. I just wondered before we move on, does anyone have any sort of thoughts on that? Note the comment about a short break. We actually weren't going to say very much more before we take the break, if that's all right. Another couple of minutes.
I would encourage evening. I would encourage evening sessions as well, because many people will not be able to make it during the day.
Yeah, I think the only thing we would say is if we were having sessions during the day and evening in each location, it makes it very difficult to get from place to place. But if all the sessions were evening, then it's much, that's much more doable for us trying to travel.
I suppose since you're putting together a form to collect information, you could ask and then take a view.
Yeah. Okay, we'll give some thought to that this afternoon. Thank you very much.
It may not be the case though that we'll be able to accommodate one single response either from Mr. Heathcote or from Mr. Kelly. We may be asking for you to fill in the form 9 times, and that'll just be something maybe you just have to accept in order that we can accurately collate the information. So try not to be too discouraged if that is the outcome in the meeting note, and fill in the form. Apologies, Mr. Kelly.
Okay, just very quickly touching on the timelines. Appendix 2 set out what were our anticipated timelines and deadlines when we drafted the agenda, and those follow the timelines, if you like, in the Scottish Government's ASTI guidelines and our reporter's guidance note. So, there's a limited amount of flexibility for alteration of the dates that we'd indicated. We've We would also ask parties to note that we've had to take into account the implications of various deadlines for the resources of our caseworking team, you know, to handle what's due to come in and out in certain dates. Now, since we published that appendix, we've had some comments from the applicant with regard to the timing of further written submissions, the dates proposed for recognitions and hearing agendas, the incorporation of the opportunity for rebuttals, and deadlines for both conditions and closing submissions. We've also had a separate submission from them on the additional information that is proposed to supply on ecology, and we have the issue of agriculture that we need to try and deal with. We've also had comments from Highland Council and Mr Kelly with regard to the inquiry timetable, and we've given careful consideration to all of those comments. So we just wanted to make a few points on those for people to have a think about before you go on your break. So what we would say firstly is that we think there is very little scope for us to change the dates of the 23rd and 30th of November as being the 2 weeks over which we would carry out the inquiry. We are aware, as was noted earlier, that there's particular dates for some parties are unavailable, and we will seek to try and schedule and programme the individual sessions according to parties' availability during that 2-week period. The period that we've allocated for community hearings, the week commencing the 14th of December, we know is not ideal, but we have again limited scope to change that. The number, dates and locations of those community hearings will be finalised once we get the opt-in responses and have been able to secure venues, and that is something that can prove to be quite challenging, particularly when it's evening venues, because quite often halls, etc., are in use for other purposes, especially the run up to Christmas. So we have anticipated that we would probably stick to those dates, but that we might also be able to fit in one of the hearing sessions, potentially the conditions hearing, in the week commencing the 14th of December. We might be able to fit in the accompanied site inspections in October. We said the week commencing the 25th, and if there's any overflow in that, accommodate some of them in the week commencing the 14th of December if we're not involved really during that period in the hearings. So before we take the break, what we're just going to say is that we also have considered whether or not we can split the request for further written submissions into 2 batches to try and take a little bit of the pressure off people, but we do have really limited scope in the final deadlines for some of the submissions. So when we come back after a break, what we'd like to do is run through the timetable we've got, and we've got some kind of potential changes to the dates. So before we take a break, I see Mr. Kelly's hand up. Was there something you would like to say?
As I understand it, you're under no statutory obligation to provide a report by a certain date. Therefore, you do have flexibility. And I know we're going to discuss it after lunch, but looking over what you've agreed in terms of additional information, the position on ratio, the submissions on ratio, etc., I think the inquiry timetable is set out just now is impossible. And my clients are simply not interested in evening hearing sessions in the week before Christmas. We need to look at a more sensible timescale. There's no rush. This isn't going to happen for years. There's absolutely no rush whatsoever, and there's no statutory obligation on you of any sort to rush this process. And I have to say, before we break for lunch, the tendency to rush gives out all of the wrong vibes to the members of the public. So I'd urge you to think about that. Thank you. We can pick up again after lunch. Thank you.
Just before we move on, I would say that, I mean, it's normal as set out in our code of practice that renewable energy developments are dealt with within a 50 to 52 week time period, and that's what we're trying to work to here. We're trying to manage it the best we can. I think the fact that we were slightly later than the other 2 parties the two ASTIs kicking off has meant that we have a conflict over the Christmas period, which we can totally understand. You're going to see if there's any scope to sort of move some dates round about that, but I think we're in a very difficult position to move the whole inquiry timeline. So we'll take comments parties make today on the timeline after we have a break. We'll consider them very carefully, we'll feed them back, and if there's any changes, we'll confirm that in the meeting. But I think that's all we can say is we'll listen. We want to hear what you've got to say. Diana Royce, you've got your hand up.
Sorry.
Sorry, Mr. Kelly, I thought you...
Yes, I
Last,
sorry, Mr. Royce. We'll just let Mr. Kelly's got one more point just and then we'll go back to you. Sorry.
Oh, sorry, ma'am, if I was cutting across someone. Just you might over lunch, it might be helpful for you to look at the inquiry timeline as you've set out in Appendix 2, because you have agreed procedures during this morning's meeting that are not reflected in that timeline.
Sure, and that's what we'd say. This timeline was drafted before certain things had changed. So we do have another timeline to hand where we're giving things some thought. We would like parties to go and have a break. We'd initially thought 10 minutes, but it's getting to the stage now. I actually think people are probably going to want to take a break for lunch.
But rest assured, it doesn't impact on your holiday plans, which you let us know this morning. So I can know.
Okay, so thank you for that, Mr. Kelly. Ms. Royce.
I'm speaking for Loth residents on this point. I just want to draw your attention to the fact that the Highland Council planning process is non-complete and that you're asking us to make decisions. Our case is purely based on the LVIA. We haven't had access to their consultant's assessment report. We haven't had access to the council's ultimate decision. We haven't had access to the report of handling. And it seems to me that you're kind of jumping the gun. How do I know whether our organisation want to partake in the LVIA hearings unless I've already seen the council's evidence?
Okay, maybe
because we work in harness with the council, and what we are trying to protect is a local designation. So it is up to them to comment initially on that.
Okay. Can I maybe just
explain? I think it's very, very unfair and it's inadequate, really, to be steaming ahead before that process is done.
Okay. It's the same position with the Beauly to Peterhead ASCA, I have to say, but what triggers the process is the objection from the council. And the council objected to this proposal way back in its consultation response, and it set out some of its comments in that consultation response. So that's what we have to work to in progressing the inquiry. It's what the council submitted at the required stage of the process. Council, well, I can understand its reasons, but the council has not been able to give us additional information. So we have to go on the basis of all the representations and consultation responses that went to the Energy Consents Unit. And that's what triggers the start of this whole process for us. Now, in progressing through the inquiry, the parties who want to participate will already have had accessibility to the documents on the Energy Consents Unit's website. All the documentation and reports in relation to the inquiry, apart from the occasional confidential one relating to ecology or private watch replies, those are all available to view on our website too. When parties start to make submissions, that's where the documents will go. We'll explain that later. But basically up to now, there is actually quite a wealth of information out there upon which any individual or any community council or community group can make their comments. You don't have to wait on what the council say about it. We're looking for your view. If you've already objected, we'll take your objection into account. But what we're giving you the opportunity to do just now is to give us, an updated version of that, or a more in detail version of what your objection is and why you object. So that's what the process is. That's how we go through it. It's not a case that we can put the inquiry on hold because the council hasn't got the application to its committee yet. That's not how the procedure works, I'm afraid. Much as you might not like it, the timeframes are very tight for everyone involved, and we totally understand that. But what I would say is that if the community feel that there is something in particular that they would like to look at, but they can't quite pinpoint, because I know it's a vast amount of information, there's something that you're having difficulty with, then the case officer will help you with something like that. She can point you to, or they can point you to, a particular document. But once all the documents that are submitted as part of inquiry become available, we'll run through the time frame after lunch. But what you'll see is that there are various deadlines, and the hearing statements that people would produce when they come to the community hearings, they're not produced until after a lot of other information is submitted. So people will have the benefit of seeing what the other parties submit before they have to give us their, the statement that they're going to read out at the community hearing. So there is still the opportunity for people to look at what's there and, expand upon the representation when they come to speak to us at the community.
There are one or two other mysteries which I'd like clarified. The council put in a very long request for additional information. Where is that additional information? I'm representing the public here who are going to be greatly affected, but that information doesn't seem to have appeared. Where is it?
That information was requested when the application was still with the Energy Consents Unit.
That's
and
right.
The applicant was indicated what they intended to submit. I'm not sure if all of that information is available online. I think some of it should be, but we have
It's not available online. The only thing is a bit of cultural heritage, new visualizations.
What I'm saying is the stuff that's been submitted. The stuff that's been submitted should be available to view online.
Yeah.
If the applicant chose not to submit certain information, then we have based our list of topics requiring further procedures on has taken into account what we think is available and what we think is missing. And that's one of the reasons why there's a hearing on traffic and transportation, is because we don't think that there's been enough information on that yet. So we have tried to take account of everything that's available to us and design the inquiry process to cover where we think there are gaps in the information, and do that to the best of our ability while facilitating the public to comment. And the community hearings give you we think, the best opportunity to do that.
It would be useful to bring in Mr. Mackay here, because he might be able to just explain a bit further the process before it came over to the DPA, when it was an application in the Energy Consents Unit, before it went to inquiry with regard to the communications on additional information and the applicant making the choice to submit certain additional information. Mr. Mackay, I don't know if there's anything that you could help with.
Well, yes, essentially there was some correspondence which explained what the applicant felt was in a position to provide and what would constitute additional information under the EI regulations, and what it wasn't possible to provide, and which might be helpful to clarify. And in certain instances, there was an expectation there'd be further discussions with the council about, for example, roads, traffic issues. If Diana Royce would like the correspondence sent on to her, so she doesn't have to try and find it in the DPA website, we're very happy to do that. We just need an email address.
Right.
I think that there are a couple of documents where I think we had raised some questions about whether they should be available and published. So if we can kind of leave that as something that we'll come back to you separately on. We think there's a couple of documents where the similar document has been published for the other two ASTIs, but it's not published for ours. We think there's maybe a slight gap in the information package that come over, and things some came individually and get missed out of the package. So I think that's not a matter for us to bring in the pre-inquiry note, but the case officer might contact yourselves just to check. I think there was one email went out yesterday or the day before on one particular item. So we will look through the additional information and see whether we think that there's gaps in what's been published and just check on that. Make sure we have everything to hand.
Right. I'd like to endorse Mr. Kelly's view that this is all very rushed and unnecessarily rushed. For a project of this scale, which is going to have such a huge long-term effect on our area, it really should have required a lot more consideration and a much better application. It is shocking.
That point has been raised in many of the representations that have been submitted to us, and that, no doubt the ministers are aware because it's been raised and has been copied.
The other matter is, although there was a bullet point on it in agenda item 1, we would probably be expecting Mr. Finlay to give us any implications or update with regard to the council's considerations under item 9, any other business. We would expect that Mr. Finlay might give us a kind of a heads up, or he may do that within the context of the timeline that we were going to discuss. So perhaps that will help you understand where the council is and its consideration of the application. But that's probably going to be after a sandwich or two, I think.
Yeah,
Okay.
I think probably.
I'm not blaming the council for this in any way. They're under enormous pressure, but I'm blaming the pressure that's coming from further south, because it's quite unnecessary.
Okay, well, I think what we've done is sorry, thank you very much, Ms. Royce.
Yeah.
We can note your concerns. We will come back after lunch and talk about what we think works with the timeframes that we had set out, or, a revised version of that. But we will take away the comments that have been made by yourself, Mr. Kelly, and others about the inquiry timeframe. And if we think there is any scope to change anything, we'll let you know through the note of the meeting, but please do bear in mind that there's a limited amount of flexibility in the process. I think this would probably be an appropriate point to break. And
I'll ponder timelines for lunch.
is 2 o'clock sufficient for parties back?
If you just keep you can keep the meeting open, but just take your camera off and mute yourself. And we'll do the same, but you can keep the call open.
Okay, so 2 o'clock, everyone. Thank you very much for that. everyone, welcome back. Hope you all got a suitable break there and are ready to continue on. Is there any points anyone wants to make before we start back up? Okay, right, so what we want to do now is have a look at the Appendix 2, which was the provisional timeline, where we think there might be some scope to change and where we need to try and fit in some of the additional items that were discussed this morning. So, a number of matters we need to cover. First of all, I was looking to seek the applicant's potential timeline for the cumulative baseline updates for cultural heritage, landscape visual assessment, and any other relevant chapters of the EIAR. Mr. Mackay, do you have a date in mind for that?
Yes, the obvious date would be the 11th of September when the foundation document list needs to be finalised.
Okay. And from where we thought we'd had that slotted in, so I'll come round to other parties once we've asked another couple of questions. So the next one was the additional information on ecology and the draft derogation. Was that the same date or were you thinking later for that one?
We're working to the same date.
Same date. I know agriculture was just sort of introduced this morning, but I wonder if you've had a chance to have a think about that over lunch and a potential timeline for having that submitted and publicised.
Well, that is a bit more difficult because I think we've been able to locate the union's letter of representation and the issues raised are fairly generalised, I think it's fair to say. And it's difficult to see how those necessarily translate to actual interests for the landowners affected by this particular project. Hence why I think it's really important that if we are being asked to address that, we're given a very specific instructions as to what's required as it applies to this particular project.
Okay. And if we had to ask for similar information as was put out in the last request for information on Beauly to Peterhead, is that likely to be an issue in terms of the timeframes we've got here? Or is that something that could be done relatively quickly?
Just give me one moment, please. Yeah, I think it's our understanding that the agricultural land use is limited to something like 10 spans. So if it was specific to individual locations, then that might be possible. Beyond that, it's certainly thought to be unreasonably excessive, if I can summarise it that way. As I say, in the absence of individual objections from the affected parties, it's really quite difficult to anticipate what might be required. But yeah, that's the position of the applicant. We could provide information if it's specific as to where it is thought to be of concern.
I think what we'll do is obviously we'll confirm within the note of the meeting whether or not we think we can deal with it as further written submissions or whether it's got to be a full request for additional information. We'll give that matter a little bit more thought and we'll confirm that. And then if we do, we'll let you firm up a date with us.
Well, I should have that. Thank you.
So the additional information on ecology and the draft derogation it said was 11th of September. Now, I'm trying to think ahead. What we need to go on and discuss are the likely order, the estimated time requirements, the timeline deadlines, etc. But what we hadn't talked about this morning was that there will be a need for consultation on the information that comes in on ecology. We need to build in timelines for Nature Scott, potentially RSPB, anybody else to comment on that. Had you given any thought to how that fits in with how we programmed our timeline? That would be
Yes, and that's why the applicant's working to that date, because it's thought that that gives the organisations sufficient time to reflect upon that information and date their topic papers or expert reports in accordance with the suggested timetable.
That's fine. What I'll do now is I'll just quickly run through where we thought that there was scope for some changes. Sorry, there's a hand up. Will we do that? Nature Scott? Yeah.
Hello, thank you. It was just to confirm that from Nature Scott's perspective, 3 rather than 2 weeks would be a much more realistic timescale to responding to any additional information that was submitted on the 11th of September. Thank you.
Thanks so much. I was going to run through all the timelines just to see whether or not we have spaced them out as best we think we can. But before I do that, I see Mr. Kelly's hand up as well.
Ma'am, are you accounting for early submissions and rebuttals on Rayshaw in your revised timeline? In every other case, the Rayshaw submissions and rebuttals have been taken very early in the process and usually involve between 4 and 6 weeks.
I will come on to that. We've taken account of the fact that we had actually kind of the ball, if you like, kicked off early in Rayshaw in this project because some of the information was sought in terms of we've got information already in from the applicant and Highland Council, and what we would be doing now is kicking off a round of further written submissions on the back of that.
Yeah, that will all take time. I've seen the council submissions, and Rhoda sent you a whole suite of the documents very recently. The submissions are very substantial on Rayshaw, and in effect, the council are saying this is a single project and the environmental information is inadequate. So that has to be addressed, unless you want to ignore it, of course. That means
no, not at all.
We could end up in court there, but
no.
The position on Rayshaw is very serious and needs to be addressed fully and early.
Sure, I appreciate that. But as Mr. Bray had said this morning, we will seek all the information and the comments on Rayshaw so that we can then make a decision on whether additional information is required. So that's the first step in the process, is us kicking off the further written submission plan. We won't take a decision on that until we have all the comments.
Oh, sorry, again, this is confusing. Yeah, but that's confusing me because if it's open for you to decide on the basis of Rayshaw that further information is needed, then based on the other cases, that information would have to be produced and then advertised, which makes a mockery of the rest of the inquiry programme at this stage.
Perhaps, Mr. Kelly, can reassure you that the behind, if you like, Appendix 2, our idea is, or not idea, our thoughts are that the further written submissions round on Rayshaw, allowing parties to comment on what the council and the applicant has said, would be to the 4th of September. Thereafter that, there'd be an opportunity, if you like, for battle of that. And then at that point, probably by the 25th of September, and it would be at that point that we would make our decision whether or not we need additional information. That's early-ish in the process, and it's at that point that we would be asking for any information. Once all the parties have had an opportunity to have their say, and the likelihood is the applicant would be able to provide their comments on that, and that in our timetable could be completed by the end of September, and then we would have to make our decision. And if that decision has any implications on the wider timetable, then we would address it at that point, Mr. Kelly.
Thank you. I understand that, but from where your starting point, you're asking us to do written submissions on an absolutely crucial issue, Rachel, within 3 days of the opt-in deadline. Back to the point made by Mr. Watson, there's no rush. There's no rush here.
Hold on just 1 second, Mr. Kelly. You'll have been able to see the applicant submissions and the council's submissions. I think you have seen them. There's been a fair lead in to this meeting. The note of the meeting produced within 7 days. And then after that, there's, if you like, a fortnight beyond that to provide comments. So it's not that there's only 3 days to provide your comments after all in, because there's quite a lot of lead into that. So I'm afraid I don't accept that point, Mr.
No, it won't work like that unless you accommodate me on the opt-in processes, because during that 2 weeks, I could be getting people to fill in, maybe 20, 30 people to fill in opt-in forms, as opposed to me doing a single form on my own. And I need to negotiate with these people. Are they going to be available to speak? Are they not going to be available? There's going to be, unless I can do a group opt-in, there's going to be a lot of work for me in that fortnight between the minutes coming out and the opt-in deadline. That's all. Thank you.
Ms. Finlay? Or Ms. Finlay, we've got to read that name at the top. Sorry, Miss Crawford. Sorry, apologies. I've got my reading glasses on and I can't see the screen.
Yeah, I'm similarly afflicted. It's really just a point of clarification relative to Mr. Mackay indicating that as far as the cultural heritage updated baseline is concerned, it's anticipated that will be lodged by the 11th of September, i.e. the foundation documents list finalisation date. The next line in the timeline says that comments and further written submissions are due by 25th September. And then we go into hearing statements in October, 23rd October. It was to clarify whether the inquiry would wish Historic Environment Scotland to comment on the updated cumulative baseline, whether that falls within further written submissions by 25th September, which might be a big ask. And I know Nature Scott, I think, made a similar comment, or whether it would be sufficient, at least so far as the update to the cultural heritage baseline is concerned, whether it be sufficient for Historic Environment Scotland to respond to that in their hearing statement.
That was our thinking on cultural heritage matters. We do have to give that particular matter some consideration, because it may impact other topics as well. But at the moment, we're considering that those matters would be dealt with through the further procedures, if you like, the hearings, and
that would certainly.
I think that's more manageable with regard to the timescales. If there is any topic that isn't related to any further procedures, then we'd be happy to run further written submissions for that in parallel. But I think as far as cultural heritage would be concerned, that you'd be addressing that through your hearing statements.
Thank you.
As far as the scope of the hearing is concerned.
That's very helpful. Thank you.
Ms. Cleland from RSPB.
Hi, thank you. It was just really a sort of similar point to Nature Scott and HES, just in terms of the order of the further written submissions. And I'm not sure if you're coming on to proposed maybe changes to the date for the first further written submissions. I know the applicant, I think, suggested the 4th was changed to the 25th of September. 25th of September date. But just being mindful that the information that's submitted, potential on cumulative impacts or other matters for ornithology, are likely to affect our further written submissions on ornithology, and there might not be a hearing session on that. So just in terms of the timescales, we'd obviously be keen to have the opportunity to have time to respond to the new information, like the shadow derogation and cumulative matters, yeah, just how that tied in with the further written submissions on those topics.
I was very conscious over lunch that I hadn't invited you to speak earlier.
That's right.
And you had your hand up. So would RSPB be happy to participate in a hearing session on the ecological matters? Now, most of them are about blanket bog, but there is one ornithological matter that's included in that package of additional information. I presumed you would want to comment on it, but I wasn't sure whether or not you'd want to take part in the hearing.
Yeah, and I think part of our decision on that would depend on what information is submitted, because our letter that was submitted in response to the consultation, part of that does relate to kind of further commitments or further information. So yeah, I suppose just now at this stage it might depend on what matters would be left for a hearing session and whether we would take part in that. But it certainly wouldn't be our intention to take part in the sessions on blanket bog or the SAC.
Basically, if the hearing was going to address the effects on the SPA, that's where you would potentially have a role.
Yeah, potentially. In terms of there's the two SPAs, and yeah, for instance, particularly on the Strathcarnargan, Strathfleet Moor one, yeah, some of our comments related to commitments and potential mitigation that might be in place. So it's quite difficult for us just now, without knowing if the applicant is going to seek to address those matters, what our position might be.
Yeah, okay. Thanks very much for that. So, no other hands up. Well, what I'll do is I've got the original timeline, and I've got what Mr. Bray himself have sort of discussed as potential changes. And I'll run through these, and then I'll come round and seek parties' comments and obviously I know that there are parties who think not going to work, but I would just like views on the review dates that we're proposing. So don't propose to change the first date for further written submissions. If you're going to go to September, with what we haven't decided on yet is what would be included. We're proposing to try and split the further submissions into 2 batches to try and minimise the effects best we can, both in terms of parties submitting and also our own caseworkers. So the initial batch of further written submissions would be due on the 4th of September. Comments in those further written submissions would be on the 25th of September. And the second set of further written submissions would be issued on the 12th of September. We had agreed, I think, that they would come back 2 weeks' time, which would have been the 16th of October. Additional information on blanket bog, peatland habitat, draft irrigation, etc. would come the 11th of September. The 11th of September would remain would be the date, we would issue the second set of further written submissions, the date that finalised documents list is produced. The week commencing the 14th of September, we would seek comments on the additional information on ecology from RSPB, Nature Scot and potentially other relevant parties, if need be. So the date of the 25th of September, we reckon would be still remaining the second batch of further written submissions. Potentially, we would need to have, if any information has got to be advertised under Regulation 21, it would need to probably be around about the 25th of September time. I reckon 25th of September would also be the date that draft conditions would go to the council from the applicant. And the draft advert. We produced the 12th of October.
The draft public advert for the PLI as a whole.
Inquiry as a whole. 16th of October. What we're proposing is bringing the inquiry and the hearing statements forward a week to that date to allow for any rebuttals by the 23rd of October. Okay, and the 16th of September would also be the date that, as I mentioned earlier, we would have comments on the second round of further submissions. The week commencing the 26th of October, we built in that week as potential company site inspections for cultural heritage and residential visual amenity. No change to the dates of 2nd November, which would be when recognitions are due if there's any inquiry sessions, which might now not be the case, but that's the date that would remain if there were inquiries. 2nd November is when the hearing agendas would be issued by ourselves. The week commencing the 6th of November is when the foundation documents and supporting documents would be finalised and published by ourselves, with information coming from the applicant. The community hearing agenda and timetable we hadn't intended to publish until the 16th of November because that gives us a bit of time to work out how many parties wish to actually participate and arrange for the venues, and also given parties who wish to be involved in the more formal topic-based hearings as well as the community hearings, that splits the submission deadlines a little. Week commencing 23rd and 30th of November remains the same for the inquiry and the hearings. We have left open the date for any accompanied site inspections around the inquiry time. And the week commencing the 14th of December would remain for the community hearings, but we would hope to fit in the conditions hearing and any remaining site visits. We had initially put down the 18th of December for closing submissions and case summaries from council, community councils, other parties, everybody except for the applicant. And we know that's tight to Christmas. However, it's quite far, it's a few weeks after the deadline or the dates of the actual oral sessions. So we felt that that's still workable. But appreciating that then leaves it too tight for the applicant to respond before Christmas, we were suggesting the week commencing the 15th of January for the closing submissions from the applicant. That would all, if those timeframes are stuck to, that would push our report to ministers to probably towards the end of April. So very, very tight. What we'd like to do first of all is ask Mr. Mackay.
Just one point of clarification is to give reassurance on what further written submissions that we might go out. And this is just our initial thoughts, and I'll clarify it in the meeting, but it was on the point that Mr. Kelly raised on ratio to come out. That would be part of the first batch, and the matters we discussed earlier with regard to clarifying site visit arrangements and the scope of hearings for cultural heritage and residential visual amenity. We feel that we need to do that early. Similarly on traffic and transport as well. So at least it would be those 4 subjects. There may be the possibility of some ecology further written submissions by then, but those are the 4 that we identified that we needed to keep earlier in the process so that it didn't affect procedures later on. So just thought I'd give an indication of our thoughts on further written submissions, the ones that are in the first phase, and the rest of the further written submissions would be, as Ms. McCallum set out, at a slightly later date. Sorry for that.
No, we're going to take a view on that. We haven't quite decided exactly how we're going to do that because, see, timeframes are very tight. I think probably what we'll also do in the note of the meeting is we need to have a little think about exactly how we're going to handle ecology, given we're getting into additional information, and whether or not we think we can tackle it by an inquiry. We might need to give all that a little more thought, and in the note of the meeting spell out the matters that we think probably need to be addressed in that additional information that's going to come from us, come to us, sorry. So, yeah, we will finalise that list of the 2 batches of further written submissions that we've had a chance to think about it a little bit further. But we just wanted, first of all, the applicant, bearing in mind everything that's been said this morning by different parties about the process and the timeframe and the difficulties in meeting that, what's the applicant's thoughts on being able to actually achieve the inquiry timetable that was set out?
Yes, I mean, as you acknowledged fairly, it is very tight, but it is achievable, I think. I mean, I was trying to follow just what you had in mind for the September-October period, and it looks like wherever you cut it, it's going to be very busy for all involved parties. I think the only concern that the applicant had related to the front end of that timeline and the initial exchange of written submissions, so it's helpful to get some indications to what they would cover. I think what I would ask you to do respectfully is to give thought when issuing the procedure notice to what can usefully be done and helpfully be done in that first batch, because it will come only a couple of weeks or so after the procedure notice is actually issued following the PIM. And also it will come before the date when the foundation documents list is being finalised. So there may be a degree of interrelationship there. So having said that, looking at the issues that you've identified for batch 1, site visit, scope of cultural heritage and RBA, hearings that should be achievable. Traffic and transport may depend on exactly what it is you're looking for by that date. And likewise, any ecological issues might be better pushed into the second batch, I would suggest. But other than that, I would say in general, yes, the applicant would support the difficult task which you have of trying to fit everything in the time available.
Before we have a talk about like the order and the estimated time requirements for each of the sessions, I just wanted to ask the other parties, Nature Scott, or sorry, I see Mr. Finley's got his hand up.
Yes, I'd just like to reiterate the concern that we expressed in our correspondence to you with the first date for responding to written submissions. As you alluded to earlier, to update others, the council is going to be considering this more fully on the 9th and 10th of September, and to require further written submissions prior to that date will, depending on which submissions they are and which batch they fall into, will cause problems. So notwithstanding the comments you've made, our request would be to still push back the first date for written submissions post the 10th of September. And the only other comment that I would make, and I may not have picked this up correctly, but in terms of extending the date for closing submissions, I understood that you extending the date for the applicant, but what did I miss? You were extending the date for those opposing as well?
Well, we weren't proposing to do that. Our initial thoughts were if we did that, then it would extend everything by almost like a full month.
Yeah, I mean,
I tried to explain earlier was that parties who participated in the oral sessions will have done so an earlier date than the community hearings, so they've got a bit of time to prepare. You know, the only thing that they'll still be hearing.
Landscape and visual matters, relevant evidence may be given during those community sessions, which the council and others may wish to comment on, and no doubt the applicant would comment on in response. And secondly, the closing submissions are likely to have to deal with conditions as well. I appreciate the timetable is tight, but in our submission, uh, even if we could have until the 8th of January and then the applicant having extended time, I think we're pushing the applicants back in any event, that would give some scope for dealing with both those matters. Because, as you say, we could have the substance that, of most of our closing submissions ready well before Christmas, but it would be just finishing matters off after Christmas. So those are the two main points I'd wish to make in response to that proposed timetable, moving the start date back a little bit and giving us a little bit of leeway at the end.
The only thing that we need to give a bit of consideration to is this a turnaround of the documentation for the further written submissions. One of the reasons we'd split it was also to help our case officers internally, because turning around everything that's come in to send it back out is quite a big task if the further written submissions are all done in the one batch. So that's why we had hoped to try and get first lot out and back separately. But if you're proposing, you said the 10th of September, was it? Or you wasn't changing the 4th to the 10th, was that right? For the written submissions, so it's still 2 response dates. Is that right? Did I pick you up correctly?
The council's committee hearing is on the 9th and 10th, so it'd be a week after that at the earliest, if possible.
That would be the 16th, would that be right?
Yes, but we prefer 2 weeks, but I can
We may be able to accommodate that with regard to the order of who goes first in terms of who we ask information of Mr. Finlay. So although it's protocol that the applicant generally gets the final say, it may well be, given the nature of the information that we require in terms of site visit arrangements, such like the applicant can have a say first and then you could come later. So we'll try and take that into account as best we can, but we do need to move certain matters along for the hearings, but we'll try to kind of involve the council, taking into account your deadlines, if that sounds reasonable.
thank you very much. I think that's all I can ask, given the task you have in hand.
Thanks, that's appreciated. Mr. Kelly?
You'll not be surprised to hear me say that from the perspective of the local communities, the timeline you're talking about is impossible and actually unnecessary in the context of a multi-billion expenditure of our money, not SSEN's money. So that's a general point. It's completely unnecessary to rush ahead with this. Secondly, and picking up something Mr. Finlay said, based on discussions between my clients and councillors, I do anticipate relevant matters coming out of the council's consideration on the 9th and 10th, which you're not currently able to take into account in the programming. And thirdly, I can see the messages from my clients. They are pretty annoyed that you're totally ignoring the point that holding community hearings in the week before Christmas is simply not on.
Okay.
It's an impossible imposition on local people, it really is, and should not even be considered. Thank you.
Before I take the various other people who've got their hands up, could I seek the applicant's view on that particular matter, the community hearings? Because if we change that, then it has implications for the time frame, because it sounds like Mr. Kelly's saying that the only possibility is to have it after Christmas, which I'd like to see your view on.
Yeah, I'm just looking at the timetable and I wonder if there's any scope for bringing it forward by a week to the week commencing the 7th of December. Because that
don't have capacity to do that, I'm afraid.
No, and also we have an indication from Mr. Kelly, who's representing a number of parties, that he hasn't availability that week, and we've got availability issues that week as well. So that week is ruled out, I'm afraid. Very private commitments.
There's no chance of bringing it any earlier. We've had to look at all the
Yeah.
options. The only option is to push it till after Christmas, but that's got implications. So
Well,
just
that would have real implications for the timeline. It's really a matter for the reporters, and we heard the submissions made by Mr. Kelly and others. The applicant obviously wants this all oral hearings, including the community hearings, completed before the Christmas break to allow the closing submissions to be delivered shortly after the New Year break. But it may be that the community hearings, the week of the community hearings, could be structured in such a way to minimise the impact on the community. But that's a matter of detail, as I say. It's probably best discussed directly with Mr. Kelly.
I think probably one of the significant points noted from this morning was that there's a desire for the hearings to be in the evening, and I suspect, Mr. Kelly, correct me if I'm wrong, that's part of the issue is because it's in the evenings, so close to Christmas. I suspect it's the issue.
Yes, it's a combination of the two things. We don't always expect that it would be late afternoon or evening hearings, and people are going to be busy with other things in the run up to Christmas. So it's a combination of the two things, as you correctly suggest, Mel.
We will have to await the number of parties who wish to take part in the community hearings as well, and that might dictate the number and the extent to which it would impact across a week, or whether or not the scope to fit elsewhere. It's difficult when we don't know the number and the locations as yet.
I don't think that there is any realistic scope of bringing them forward earlier than the 14th of December.
I think we're quite clear on that in terms of managing the inquiry process. There's scope for bringing them forward.
If there's no scope for bringing the hearings forward, then even let's say it's 2 locations or even say 3 locations, each community would be giving up effectively a day to attend the community hearing that's relevant to them. So with some goodwill, Christmas cheer and all of that, let's hope that the communities can attend the relevant sessions. I mean, obviously it goes without saying that it's the expectation of ministers that parties who do decide to participate in the inquiry take a proactive, constructive approach to the availability during the inquiry timetable. So yes, as I say, it might be possible to minimise the impact on the community by having effectively 1 day for each location.
Is it possible for us just to butt in on this particular subject? I know we've got our hand up, but we're 5th in the queue. I've got to say we fully support Ian Kelly's line here. It's ridiculous to be thinking you'd hold community hearings the week leading, beginning 14th of December, leading up to Christmas. We need to get realistic here. It needs to go back.
And I just had a comment come in from one of the councils. They were snowed in for 2 weeks last January. It can snow here.
All procedures are subject to weather in most locations in Scotland. So I'd be surprised if there wasn't some disruption to us in terms of weather across the board. So
is it not usually worse after Christmas, January, February?
But there's no time before. I mean, Fenelon is running 2 or 3 weeks late because it snowed.
I think there needs to be a bit of a realism check on this. And 14th of December for community hearings, let's be realistic. This is a major project with implications for generations to come. We shouldn't be trying to rush this thing through and squeeze what are very, very important hearings into a time scale that is just going to be very, very inconvenient for local people.
I mean, this is part of the purpose of today, is to hear what people have to say on their timeline and how we set about procedures and the best way of dealing with things. So we're listening. We'll take away what parties have said today and we'll confirm what we think's a workable scenario. But there's quite a few hands up, so I think Nature Scott would be next in the queue to let me have their views.
we've already expressed that Nature Scott would appreciate 3 rather than 2 weeks to respond to additional information. But if I might raise one point of clarification and one request, the point of clarification is on the further written submissions dates. And apologies for any duplication here. I just want to make sure I understand what's in the mix for now. So further written submissions, set 1, would be due in on the 4th of September, and then we'd have until the 14th of September to respond. And set 2 would be due in on the 12th, with the deadline of the 25th of September to respond. Is that correct?
No.
Like that was actually no.
The first set will be issued with the note of the meeting, and the response is due on the 4th of September. The responses to those comments will be on the 25th of September. So that would be the first batch. Again, this is our draft initial thoughts. And Ms. McCallum indicated that the second batch would start on the 11th of September.
16th.
Then,
October.
yeah, it would be concluded after both sets by the 16th of October. So that's slightly different to what you said there, but that allows essentially a 5-week period for both, which is 2 to submit and 3 to respond.
Yeah, that's very helpful. Thank you very much. If I could also just make a very quick request. I noticed that the hearing statements are due on the 23rd of October. But the hearing agendas aren't out until the 2nd of November. It's just to say that Nature Scott has in the past found it very helpful to have sight of a draft hearing agenda at least while preparing hearing statements, just to narrow down the points they wish to raise. So if that were at all possible within these timescales, it would be much appreciated also.
We had pulled that date slightly forward to the 16th of October for the inquiry and hearing statements, and left the 20, instead of them being submitted on the 23rd, the 23rd was a date built in for rebuttal, any rebuttal. It's very tight to try and fit everything in, and we're trying to fit in the potential site visits in October too, so we just felt as though we needed ourselves a bit of time, and that's one of the reasons why we pulled the inquiry and hearing statements forward the 16th. And if they're all just hearing statements rather than an inquiry for ecology, then that date doesn't change. It would be the 16th of October for all hearing statements, apart from the community hearing statements. And those would be sorry, 6th November. That's another 4 weeks. The next person with their hand up is Esme Cleland from RSP.
Hi, yeah, it was just to flag again that the applicant has said they intend to submit their without prejudice shadow derogation case for the NOVA SPA as well. So just in terms of those dates and the order of dates for further written submissions, if ecology was kind of that batch 2 for the further written submissions, just to kind of flag that we or any parties wouldn't be able to kind of comment or include that within the further written submissions for any ornithology without obviously seeing that on the 11th. I think the date was that had been talked about.
It's not ideal, it's a bit late, isn't it?
Few weeks prior to the 16th of October would be the 25th of September, if that would be a better date for that second batch exchange.
Again. So guys, is it second batch to begin? Did you say?
Yes, yes, exactly. Yes. Taking out the point that's just been made.
One trouble with that is that it does potentially impact into exit procedures and such thing. We'll just have to give that some careful thought. I think, Crawford, I think you're next in line.
All right.
Thank you. A couple of points, maybe three. The first, I noted the timeline for conditions, or rather draft conditions, to be sent by the applicant to the council by 25th September. Could there be built into the timeline, please, a date by which those conditions will be intimated to other parties, ideally before the hearing statements required to be lodged, which now I have noted as being brought forward to the 16th of October, because the hearing statements may be informed to a greater or lesser extent by whatever is proposed by way of draft conditions. Secondly, I have some sympathy for the suggestion, I think, made by Nature Scott that a draft agenda might be helpful, but looking at the current timeline, that's maybe not realistic. But again, it may be useful if time could be built in for a draft agenda to be circulated to parties with a very tight turnaround for comments on that, which is kind of related to my last point. And there may be my misunderstanding, but there might have been a suggestion from you, Sir and Mum, to the effect that you would be looking to Historic Environment Scotland to hone down the scope of issues to be discussed in the cultural heritage hearing. For the avoidance of doubt, the objections made by Historic Environment Scotland remain, while of course they will act responsibly and no doubt will take account of whatever setting conditions or indeed continue to work with the applicant. They do not intend to withdraw their objections at this stage, unless and until something exceptional were to happen, which, as I say, does kind of relate to the scope of the hearing, the draft agenda, etc. Historic Environment Scotland have lodged their objections and they stand by those. Those are the 2/3 points I wish to make.
In terms of the scope, that's more orientated towards the council and other parties who have made submissions on cultural heritage, although I never said that earlier on because we haven't finalised exactly what we're going to ask you yet, but it's likely not to ask you questions on that matter, clear on it, but we would probably look for your assistance in scoping out what might be useful for site visits in that written submissions.
Yes, and I think I've already indicated that Historic Scotland are more than happy to do that so far as providing a draft suggested timetable of foresight inspections.
We did give some consideration to the possibility of draft agendas because they are quite useful, but we just didn't think we had time to build them into the time frame. Give it some more thought, but
it's unlikely given the number of hearings and further written submission requests. It's unlikely, let's say, it'll be more of, I would imagine, more a traditional approach to setting out the scope of the hearing in the note of the meeting, or it being refined by further written submissions, and then preparing an agenda on the back of the hearing statements that have been provided. So I don't think you can expect draft agendas in advance of hearing statements. I think that's just that's unrealistic as far as we're concerned.
Aldridge with her hand up next.
Sorry, could I just when, if at all, other parties may see the conditions which are to be submitted by the applicant to the council?
Sorry, so does the applicant have any issue with at the same time as they provide them to the council copying in the other parties, other relevant parties? They can be then working on it at the same time as the council's refining them?
Yes and no. Experience suggests that it's almost always fruitful to exchange with council first and then provide that revised draft. But in principle, no. But yeah, there is that issue that attaches to it.
Ultimately, on conditions, what we will be requesting and hopefully be clear through the note that it's the final statement that will be prepared by the applicant with their understanding of their position and other parties' positions within that statement. Leading up to that statement, we would expect the applicant to fully engage with all the relevant parties to the elements of it. And that was really just a starting point that the applicant, I think, had given us in their submissions, that would be the earliest point that they would get the conditions to the council. But we would expect the applicant to liaise with other relevant parties on specific matters. I'm sure, Mr. Mackay, that would be your understanding.
Of course, yes, of course.
Sorry, sir. There's another matter which I've been asked to draw to the inquiry's attention. The mid 2 weeks of October are school holidays, which certainly, so far as Historic Environment Scotland, will give rise to considerable difficulties in lodging hearing statements and rebuttals, because it will be bang in the middle of those holidays. I'm not sure that what, if anything, can be done about it, but I feel probably I should draw that to your attention. I imagine others at this meeting may be subject to the same difficulties.
Thanks. That's an important point. Let's see. Carol, looked you had your hand up for a while.
Hi there. I'm a little bit concerned. You both said at the beginning of this meeting, way back when, that this was meant to be a fair, transparent and open process of inquiry. Yet, time and time again, we keep hearing that the community hearings are being more or less their opinion. In reality, it's not about getting ready for Christmas jollies. It's about the fact that it's late in the winter. Nights are drawing in. If we went after Christmas, nights would at least be drawing out again a little bit more. We have icy roads. We don't know where the community hearings are going to be held. We're thinking about evening meetings. We have volunteers trying to get our heads around all this legal jargon. And you're trying to get us to do it just before Christmas. Retired people, volunteers. I think a little bit of leeway would be very useful to prove that this is an open, transparent and fair process.
I'm sorry if it came across that I was going to the applicant first, but I wanted to get their position before I went round everyone else, because I thought it was fair to do it that way, and then everyone could comment on it. So, boys.
Just one other thing. Evenings, yes, but I think maybe early evening, because, like I say, a lot of the people I represent are retired, elderly, and don't really want to be driving around late at night.
We've not reached any decision on where they'll be, when they'll be. We're hearing what people are saying. We are going to have a chat hopefully this afternoon about how that, nothing is absolutely set in stone. We've been trying to work to these deadlines.
I just think that the deadline is too tight on such a multi-generational impact and multi-million pound project. Are we going too fast? But thank you for listening to my comments.
You're welcome. Thank you. Mr. Kelly.
Thank you, ma'am. Just 2 points. Going back to something Mr. Mackay said a while ago, the evening sessions, the community hearing sessions might only involve one day for each group, but I'll be representing 4 or 5 groups, so it could be the whole week for me there. And secondly, I know your IT colleagues will see the chat, but I'm getting messages saying that people are finding it very difficult to follow what looks like an even tighter timeline when they don't have a written document in front of them. They don't actually have an updated timeline in front of them. And I mean, I'm used to these things, and I've been finding it very, very difficult to follow. And everybody's certainly feeling very, very pressured. I cannot put it across to you enough. The feeling in the communities that this is all unnecessary. really.
Well, appreciate that we had to prepare the revised timetable to talk about today after receiving lots of comments this week from parties, including yourself. So we've done our best to try and make suggestions to see whether that's still workable. But we hear what you say, Mr. Kelly. Okay. Shall we move on to the...
Just maybe in order that we can have our options clear in our mind, and it's not a proposal, but it's just an option. We've been quite clear that we don't think we'll be able to pull forward those hearings on the week beginning of the 14th of December. Does the applicant consider at all that the other weeks in November, if they were to be used for community hearings, could other procedures be on that meeting? This is just a little bit off the cuff, but it's just to try and find if there is scope within we've got 3 weeks essentially set aside for oral proceedings, which are the 23rd of November, the 30th of November and the 14th of December. We've had the availability of a variety of parties in the first 2 weeks. I think the only scope within the current timetable, without pushing it beyond Christmas, is to work within those 3 weeks. So I don't know if the applicant has got any thoughts on that.
Yes. No, the only reason I'm pausing is that Ms. McMillan rightly points out that we would need to double check the availability of the relevant witnesses if there were to be substantive hearings during the week commencing the 14th of December on environmental topics. But subject to that, I don't think that would be a big issue. I think, to respond to your off-the-cuff suggestion, it might work. And if it would help the local communities, then great. The only other suggestion, which I think is one that SSEN has made previously, is that perhaps the community hearings could happen before the scheduled inquiry sessions towards the end of October, beginning of November. I think I'm right in saying that for the teacup project, that was the order that was followed there. But again, that's a bit of an off-the-cuff suggestion, but it might be of assistance or it might not.
They didn't have the amount of hearings to deal with that we've got in front of us, so I don't think there's any scope to bring them further forward. My worry about swapping them over is then the information from the community's got to come earlier, and I think that was partly what Mr. Kelly was a bit concerned about earlier as well, is the burden and trying to turn things around.
I don't know,
The other issue would raise, of course, is that there would inevitably be a delay in the exchange of closing submissions into the new year, but that I think is inevitable anyway based on earlier discussions. So, but it would have to be something that was more in mind.
I'd quite like to hear Mr. Finlay's view. Planning to accommodate the community hearings earlier in the 3 weeks.
I think the council will be broadly neutral on that aspect. It's likely will only be, if at all, have a listening presence at the community hearings. So the council will be neutral on that.
Result of that other part of the timetable.
I think in order to give this full consideration, because it is obviously a serious matter, I think we will take 5 minutes just to ponder it. And 10 past, say.
Yeah.
If we can come back at 10 past, I know this is prolonging the meeting, but just if we can come up with some potential solutions, then we'd like to take this opportunity to do that. So
sorry, just before you adjourn, if I could just interject with the suggestion that the cultural heritage session might be pushed back to December, Historic Environment Scotland would not be neutral about that, and their preference would be to maintain, albeit there are the October difficulties with holidays and all the rest of it, but they would prefer that cultural heritage be dealt with at the early part of the inquiry rather than at the tail end of the inquiry.
That's the week beginning.
Pardon? They've not seen it. It is on the record there.
Yeah, okay.
So what we'll do is we'll encourage everyone to just switch off their mics and their camera until 10 past, and then we'll return then. Thank you for that.
Jeez, this is just torturous.
Switch off their mics and their camera until 10 past, and then we'll return the. Switch off their mics and their camera until 10 past, and then we'll. Switch off their mics and their camera until 10 past, and then we'll. Switch off their mics and their camera.
Hi, is everyone able to hear us? Has everyone had a chat? Let's go back. Okay, we have a suggestion to make. Okay, if we, in week one of the inquiry, which would be the 23rd week commencing the 23rd of November, if we have the cultural heritage and landscape and visual impact assessment hearings that week. And in week two, which would be the week commencing the 30th of November, if we have the community hearings and the traffic and transport hearing that week. Okay. And week three, which would be the week commencing the 14th of December, if we have the ecology hearing, conditions hearing, and agriculture hearing. I know that swaps things about a fair amount. What that would mean is that the inquiry and hearing statements would still stay at the 16th of October, but it allows a little bit more time. Given that we weren't quite anticipating additional information on ecology, it gives RSPB and Nature Scot also a little bit of time, as well as the community, perhaps accommodating their desire to avoid the pre-Christmas period. So can I maybe initially start with, should we say, Mr. Kelly?
I think so, but
Yeah, Mr. Kelly, is that helpful to swap it around and have the community hearings in the middle week of the inquiry instead of the week commencing the 14th?
Obviously, I need to take instructions on that. I would have to look at the itinerary. It is possible, but I'm saying it is possible in the context that we're not happy at all with the overall timeline that you're proposing. But I will take instructions and look at that, take your point, when we see it in the context of the overall revised timetable.
One concession we might be able to make is we might be able to push the date for the community hearing statements back a few days here or there, just to give us a little bit of play. But okay, here we have to see.
we are aware that Mr. Heathcote has to leave as well.
Yeah, so Mr. Heathcote, do you want to, yeah, we've got sorry. Yeah, sorry, I forgot to take a note of your name earlier.
Yes.
Community
It is. It's Ron Macaulay, Spittal Community Council. I'm quite happy to stay on for a bit longer.
Yeah, that's it. You could, obviously, Mr. Heathcote and yourself have been representing a group of community councils. Would that you know, first impressions, does that ease the burden on yourself by bringing it forward a bit? Is the best we could do would be to swap the weeks of the inquiry. We can't swap the first week, it's too difficult, but
yeah, I've got to say again, as Ian Kelly has said, I'll need to go back and consult with the other community councils because they're listening, but they're not sitting beside me. I've got to say, if it starts to put more pressure in terms of deadlines for you know, further written submissions, all these sort of things, then I'm going to start having concerns. I still think pushing it back would be the most sensible solution, and would probably be the best all-round solution for everybody.
okay. We, you know, there is a lot to try and juggle in this, so we will.
I fully understand, but quite frankly, you know, as it is the case with Ian Kelly and the people he's representing, we're talking about lots of volunteers giving up their own time to address these sort of things, which is quite a contrast to, you know, SSEN's position, where they have lots of people working on this full time. It's quite a different ball game altogether. It's a bit of an unlevel playing field, you know.
And I think that's what we're trying to also do, is build in enough time for people to make their further written submissions and to look at the additional information that comes in. And it does become a little bit tight in that kind of October period. So yeah, take your point.
Yeah. But pushing it back is a better thing.
To get the applicant's view and perhaps the council's view on those slight revisions, Mr. Mackay.
Yes, in principle, that does seem workable. A couple of things to check. One would be in relation to the second week where the community hearings would take place. That's the week beginning the 30th of November. Is that on the assumption that the community hearings would happen at a centralised location? So the location for the inquiry. Is that the intention?
No.
No, that would be based, as we said earlier on, that would be based on what we get back in terms of the number of participants, but we had suggestions of up to 4 venues from the community, from Student 1 and 2, so more than likely split.
I follow now, thank you. So the traffic and transport session would happen at one of those locations?
Yeah.
Yes.
All right.
All of the locations would need to be suitable for webcasting. Is what we plan. Whether we can actually webcast them all due to staff resources, we don't know for certain yet, but we at least want to choose venues that are suitable for webcasting, so that if we had to have a hearing that week, we could still do it.
Nice, thank you. And the only other thing.
But what I should have said was, and I didn't say, was that in that week 3, if any of those needed, or there was a preference to make them virtual, that would be another potential change if it helped. So preferably the ecology session in person, but if it meant that parties, like for example for conditions, couldn't all be there, we could perhaps run a virtual session from one of the locations in the second week. Sorry, the third week.
Thank you. And the only other thing would be just to check the availability of the venue for that week, beginning the 14th of December, which may or may not be affected by Christmas parties and community events and so on.
From the council's point of view, do you have any comment on potential changes?
In broad terms, I think the council could fit in with that. My understanding is that the landscape and visual session will be taken early in week 1, and hopefully any cultural heritage that the council was involved in early in week 1. Then as to the third week, there might be a condition session in that week. The only issue, I'm at present unavailable on the Friday of that week, but that may be able to be accommodated within any timetable. But subject to that, on the 18th of December, subject to that issue, moving matters to that week, which would be in a more central location, no doubt, and so less prone to weather interference. Unless I'm told otherwise, I think that should be it would be acceptable to the council.
Shall move on to Ms Crawford.
Thank you. So far as the swapping around is concerned, that gives Historical Environment Scotland no concern. There is, however, perhaps one point I should raise under reference to my earlier noting that the October dates clash for lodging hearing statements and rebuttals clash with school holidays. That being so, I wonder if we could retain the hearing statements being submitted by 16th of October, but provide parties with 2 weeks within which to lodge rebuttals, i.e. By the 30th of October, which, looking at the timetable, I think would work. Again, it's very tight, but it does give a bit more leeway for parties to consider all other parties' hearing statements and respond in a meaningful way. Otherwise, the danger is that there may be a lot of placeholders put into rebuttals, indicating that there hasn't been sufficient time, but the matters can be addressed more fully at the hearing session, which may not be the most productive use of a rebuttal statement, and indeed may take up unnecessary time during the hearing sessions itself.
I mean, that brings a little bit into conflict with what we discussed about site visits, because you're right, or you would refer to all the submissions in front of you before any accompanied site visits. So we'll take a view, I think we'll take a view after the meeting on whether or not there is a requirement for rebuttal. We've included that because I think it's suggested as a potential in the ASTI guidance, and I think the applicant has raised it, but it may well be that there appears not to be sufficient time for rebuttals, so we may just be satisfied of going just straight to a hearing without a rebuttal. So if that is the case, then that'll have to be accepted by the main parties, I think.
I think that was the case in the other two ASTIs.
Yeah.
Mr. Heathcote. Oh no, it's not Mr. Heathcote. I can see my glasses on. I'm looking at that screen and I can see the face, but I can see the name here. Sorry. Mr. Macaulay.
Oh, well done. Thank you. I was just going to say, I'm finding it increasingly confusing as to what this final programme looks like, the way we've been talking it through. And I just think it's getting to the point of, I need to see this in writing, or I need to see something that we can look at before we can really give you considered comments on it.
Can I just stop for 2 seconds? Is it okay? We'll still got meetings.
Apologies for another delay. Whilst, and as I said earlier on, we don't look for feedback on the minute of the meeting. It's like a set of procedures, but I think what we can do is, as part of the first batch of further written submissions, we can ask for comments on the timing of particular procedures and questions around that. And that will help us finalise certain elements. So we'll try and, if you like, be accommodating in asking people's views on matters. But what we won't be able to do is, if you like, put the note out and look for comments on the note. So we'll ask a series of questions in our note around about the end of the inquiry and the exact timing of it and the detail of it. And that will hopefully give parties the option to feedback on that before we absolutely finalise the end timings. I think that's probably as good as we can do today. And that'll be either on the 1st of September or the 4th of September. So we'll set that out in the note, not comments on the note, but we'll ask some questions around just how those procedures will work in detail. We may also go out to specific parties that have raised matters about availability before we complete our note as well. So we might be talking to Mr. Kelly or Mr. Heathcote, or indeed the applicant or the council, Historic Environment Scotland or Nature Scot or RSPB, before we complete the note in order to discuss availability. So please be ready for that. I think that's probably as far as we're going to get today.
I think
Thank you.
just taking that into account, that we might delay the issuing of the note by a day. We'll see. I think we've got an awful lot to try and think about and iron out in the space of quite a time when we're trying to issue further written submissions as well. So do our best to get the note out by Tuesday at the end of the day. But if you could bear with us if we're 24 hours over, that's okay.
Yeah, because we're trying to sort of sort everything out, so it's slightly easier to follow, because you're probably not the only one who's finding it difficult to follow this. But it's not all we need to go through.
Well, what we also want to do is, I see Nature Scot put their hands up. I'll come to that just a second. We wanted parties to also give her their kind of idea on the amount of time requirements for each session, which I think we've probably got a fair idea of. But before I do that, I'll just ask Nature Scot for their question.
Thanks very much, Malcolm. It's just that I've just had instructions on the proposed rescheduling of the hearing statements deadline to the 16th of October. I think that's going to be difficult for Nature Scot, just in light of what Ms. Crawford was suggesting in terms of rebuttals by the 30th of October. Changing the hearing session for ecology to the week commencing the 14th of December is fine in principle, subject to detailed confirmation of availability. And I'm sure you were going to come to this in due course, but we would request an extension to the lodging of closing submissions and case summaries if the hearing is pushed back. Thank you very much.
Whether we can possibly, the hearings are over 2 separate weeks, whether we could have 2 separate dates for hearing statements to come in. Might be a possibility. I think we've got an awful lot to try and think about. I think what we'll do is, Mr. Braces will try and circulate an email with a revised timeframe till the main parties here today, and see if we can make this work. Or at least get comments back before we finalise matters. Okay. Yeah, so sorry, don't see any hands back up. My computer's trying to restart. So in terms of the running order, were we content that it was landscape and visual impact assessment first and cultural heritage, and we're content that we both fit into the 4-day period we've got that week, commencing the 23rd of October, commencing on the Tuesday of that week? Would that be correct? That's what we had initially indicated. Like, the only person that might have some conflict with that was the council. Mr. Findlay?
As I said, as long as the landscape and visual is first, and then any element of cultural heritage that involves the council is session, which should be short in any event, then that is perfectly acceptable.
So that's starting on the Tuesday, Wednesday, Thursday, first week.
Yeah.
All seems doable, and then we'll deal with the order of the other hearings, I think, in our note of the meeting. That sound fine? Anyone got any comments in terms of the running order? It is going to be really difficult with all the deadlines. So if everything is as tight as it's going to end up being, it's going to be really important. And it's to the deadlines once they're issued. That's the only point it would be before I hand it back over to Mr. Bray.
If submission of additional information or any matters that the applicant has proposed to submit, then if those aren't hit, then that's likely to have a significant impact on the timetable as well. So I think it's not just a matter for third parties. I think if they'll be well aware that if time frame slips from their perspective, then it does cause problems. Quickly run through document management now. It's not a very exciting topic, but we will explain it in our note. You will be asked to use, those that are taking part in formal oral processes will be asked to use a platform called Objective Connect. We'll provide guidance on it, and it's an upload, it's an app in a sense that allows you to upload large documents that wouldn't otherwise be emailable. So most parties seem to find it useful. You'll hear the word foundation documents mentioned by us, and you'll see emails circulated on them. Those documents are the core documents that make up the application, the responses on the application, the consultation responses, any additional information, and anything that's been submitted in advance of just now, really. They form the core foundation set of documents for the inquiry. We will be asking the applicant to lead an exercise of coordinating a list with reference numbers and talking to the main players with regard to finalising that set of foundation documents. The applicant will be no doubt fairly well versed and used to doing that, so I don't think I need to go into that in much detail just now. But there will be deadlines set in our timeline for when the foundation list has to be sort of complete. Other documents that you'll hear referenced by us and other parties that are supporting documents, that's essentially all the documents that come after, so things like hearing statements, precognition, further written submissions, essentially much of the evidence that is brought about by the inquiry would be in part of the document list called supporting documents. It's really important that each party taking part in any process provides lists and documents to us and also the details of them to the applicant so that the list can be amended. The list is very important with regard to hearings and inquiries. Once you get there, you've got to have a list and access to all the documents in quick order in order to look at things while you're going through evidence. So it is a critical part of the process and will run through the timeline. We'll be asking the applicant and the council to liaise these matters, Nature Scotland, Mr. Kelly and others to liaise in these matters. We'll also reiterate the submission deadlines in the timeline, but we'll also rely upon the applicant and the council to liaise where the display of documents will be for the public. And if you can advise our case officers where any member of the public could access the EIA and associated documents, that that would be useful. So we'll include that request in the note of the meeting. I think I've explained earlier on what we would expect in terms of documentation for conditions. So that's a written statement submitted by the applicant, having consulted quite a number of parties, and it sets out the applicant's position on conditions and what the other parties are saying on those. But we would expect that the evidence that we need for the hearing is just simply that statement, and they would construct the hearing agenda around that statement, and everyone would be, who wants to take part in that hearing, would be able to orally contribute at that meeting based on the statement submitted by the applicant. Small matter with regard to closing submissions, we've discussed them. It's not with regard to timetables, but we will be expecting that the closing submissions would consist of a small summary of case on the particular topics, and any other submissions that each party may choose to make. And there's a template for that, and we would send that out. So I think that's probably all I've got to say about about documentations. But we did have some discussion earlier on about closing submissions and the deadlines for closing submissions, and allowing for downtime over the festive period. And I think there was a suggestion by Mr. Finlay that the 8th of January be the submission time for all other parties, and then that would push back the applicants to the 22nd of January. So it might be useful just to get, first of all, Mr. Mackay's views, given that your own thoughts were that you needed just a little bit more time into January. We're proposing that we would accept Mr. Finlay's suggestion of the 8th of January for coordinating all the closing submissions for third party. We don't expect Mr. Finlay to coordinate them all, but we expect them to be submitted then, and that the applicant would have their closing submissions submitted on the 22nd of January. I know it just adds a little bit of length to the process, but I think it's going to be necessary given everything that we've got proceeding. So, Mr. Mackay, are you content with that?
In principle, yes, although it may be that the those involved in the third week, the week commencing the 14th of December, that's primarily Nature Scott. If they have an issue with submitting their closing submissions in accordance with that deadline, that may have some implications for the applicants being able to respond by the 22nd. But as far as the council submissions, I don't imagine that poses any particular difficulty pushing it back to the 22nd.
Any other party got any comments about the closing submission dates? Then that we're essentially it's been moved a couple of weeks. We have one hand up from Nature Scott.
Yes, sir. It's just to reiterate that we would request some additional time to prepare closing statements and statements of case if we are in the third week of hearings. As Mr. Mackay has already pointed out, I still need to take detailed instructions on that, but my preliminary view is that additional time would be welcome. Thank you.
Yes. Mr. Mackay, would you need the full 2 weeks, if you like, after third parties, or would you be?
Yes, that will be if there is a hearing of some sort. And I think Nature Scott's position earlier was that written submissions might suffice, but filling which a hearing. And if you're persuaded that a hearing is appropriate, then Beauly still needs a fortnight to respond to whatever submissions are submitted by Nature Scott. So if their submissions are pushed back, then the applicant will want time to respond to those submissions. And I say that because of the relative importance of the issues in terms of the statutory and policy background.
So if we do consider that that's a reasonable request, it may well be that third parties submitting on the 15th be on the 29th, but we'll give that some more detailed explanation. That's me.
There's multiple case officers who are providing administrative support in this case, and we have a dedicated email address which is being regularly monitored throughout the working day by various people. The note of the pre-inquiry meeting will include details of that email address, and that sort of brings us up to date with all of the procedural matters. So just asking if anyone has any other business in before we start winding things up. Mr. Kelly.
Like, I don't know whether the other community groups represented by other people here will join with my group or not, but the indications I am having from my clients is that we will be sending a formal letter to you in the next couple of days, simply pointing out that today's proceedings show beyond any reasonable doubt that this is far too rushed for the scale of the project. I'll draft something and hopefully the other community groups will sign up for it too. Obviously, looking ahead, it's going to be a rather formal letter, but it's appropriate I should say to you that we will draft this and it'll be coming in, and we'll make every effort to get it in this week, given the pressure we are under with the minutes of the meeting. Thank you.
Thanks for letting us know, Mr. Kelly. Thank you. And Mr. Macaulay. All right, you're on mute, Mr. Macaulay.
Right about that. I'll be happy to speak with you on that. My point I was going to raise was on Appendix 1, the last item, or second last item in Appendix 1, the issue of need. I'm right in saying that we haven't quite discussed all these last items of Appendix 1, and I'm not suggesting we go back and do so, but are we content that further written submissions will be acceptable in all of these different points? I don't know if that was actually clarified, including particularly need.
No one's objected to us dealing with it by further written submissions, so we had presumed that everyone was content with that. Okay, so it falls within the remit that you guys have to consider need, yes? Yeah. Okay. So that would be included in the one of the two batches of further written submissions.
Just in case anything's read into silence on the part of the applicant on this issue, just to make absolutely clear that the applicant in their written submission will be saying that they essentially adopt the practice of ministers as to how they approach the issue of need, which is to leave issues of technical justification and economics to National Grid, ESO and Ofgem. But insofar as the policy benefits, wider benefits are concerned, that's
okay, these just for my own benefit, these are based on the documents, the Ofgem and the HND and the NOA update. These are the documents you're referring to, yeah.
Well, probably won't. There's a excuse me, Mr. Mackay. We probably won't go into a debate just now about need. What we will be doing is asking specific questions on that in terms of further written submissions, and if groups opt into the process going forward, then they'll have an opportunity to do that, and indeed likely in closing submissions as well. So I think there will be opportunities, including community hearings as well, to make sure that we're aware of your views and other people's views on those matters. But there will be specific questions on that matter. I think it's in the second tranche at the moment. But we'll
finalised yet. Yeah, that is listed. So we do have some questions on that.
Okay, thank you for that. The one other thing I was going to say, in the minutes of the meeting, will you include the comments that have been flowing through the chat side of things?
Probably not actually include them as matters have been discussed, but what we will do is we will take them away and we will read them. And if we can address any of the points, we will do. What we just won't is say these are the comments that were made. We won't run through that. We will address any matters that we think we can. Probably most of them, I would imagine, relate to the timeline. I've not seen them, but the feedback we were getting was that initially it was on the locations, but I suspect the timeline will feature in there too.
Okay.
These are all comments that have been made by participants in the meeting, although we haven't looked at them, so I'll take them. But it's not a minute of the meeting, let's be clear with that. It's a note of the agreed procedures going forward, so we won't be verbatim covering everything. You would have to look back on YouTube to see what was said. If you wanted to go through it all again, Mr. Macaulay. The one matter that I did provide a little hint towards Mr. Finlay, if he was going to say anything on the council's deliberations on this in terms of implications and timetables, but because he's not said anything, or you have said some matters with regard to the dates of the council's consideration and the potential implications, but is there anything else that is relevant to our consideration? We're not expecting new issues, to come out of the woodwork and such like. But is there anything else that we could say on the council's consideration of the matter?
I don't think there's anything in particular. I don't think there's any new issue that is likely to come out that you haven't covered during the course of your agenda. There may be issues that the council, it may go either way. There may be issues that the council doesn't object on that it looks as though it currently is, or it may add issues. But having discussed all the matters in the course of the agenda, as far as one can anticipate, all the matters the council wishes to raise, particularly as you've got woodland and water and drainage as additional further written submission topics, are covered somewhere. So I don't anticipate any additional matters coming out of the woodwork at that meeting at the moment. That said, that councillors are in charge of the woodwork, so one doesn't know what will come out. But I very much hope that everything that you've dealt with this afternoon will cater for any nature of the council's objection.
Good. No other business. So we will do our best to have the note of the meeting out by the Tuesday next week, 18th of August. And what that will do, we'll set out what we think are our conclusions and how the inquiry will be conducted and the relevant deadlines. But as we say, we'll try and find some means of incorporating an ability to comment on the timeline and the deadlines. Going forward, once those have all been agreed, parties should obviously adhere to them and keep them as the reference point for the proceedings going forward. So the note, important point to make, will be issued to all the parties who have already opted into the inquiry, those who responded to our meeting, our letter the 19th of June, people who are listening and not actively participating today, you will be contacted to say that here's the link to the note of the meeting. But you need to remember, as we've said probably numerous times, is that you do need to actually reconfirm your position that you want to participate in particular parts of the process, whether it be a formal topic-based hearing or a community hearing. We need to have the numbers for those confirmed. We will have a wee look before we issue the note of the meeting if there's a way of finding that, take account of what Mr. Kelly said to us, then we'll do that. But we do need to know that people are definitely going to want to participate. If you don't confirm, then we are likely to consider that you don't want to be involved from here on in. Assuming there's no final points anyone wishes to make, I'd just really like to thank everyone very much for their patience with us today, and hope to see you all sometime round about.
That's been really, really useful for us tasked with conducting the inquiry. I know it's been a long meeting, but that's been really useful from our point of view.
Useful, and I hope the people listening at home feel that it has been useful and that we have heard what people are saying to us today. Okay, thanks everyone.